about later, not during this conversation.
Okay.
but later.
We'll have to take turns with forum issues, because I may have to go to the project office between 10 and 11 as well. Good morning, it is the Economic Development, Housing and General Affairs. We are planning to vote out H121 and act relating to consumer privacy. And we have the Ledge Council in the witness chair to talk about final changes.
Morning, everyone. John Gray, Ledge Council. Sorry, Magali, I think the invite I have in my calendars for yesterday.
Oh.
Yeah, I could get a new one. That'd be great, thank you. Just a sec.
We chat.
All right, breakfast has been rushed then today, like non-existent.
So just to preview, the sets of changes will actually be, I think, relatively quick to walk through, just pending questions. Some of this is, fairly significant, but in terms of number, it is relatively limited. So let me close screen sharing.
So it's what's not here, I think is,
Yep, and I'll call out although it will be apparent in highlight because some things have had to be addressed in their absence. But,
so
so I will, unless you guys want me to walk through the entire bill, given that you might be voting today, just jump to sections that have relevant changes. So there's a couple of changes in the definitions section. This is starting on page 2. You will see that the definition of biometric data is highlighted here. What's changed here is that we previously had subdivisions 7 and 8, which were addressed to depictions, images, or recordings, and data derived from those depictions, images, and recordings. This would constitute biometric data under the previous draft. This removes that to align with the approach taken in other states, that attempting to make images part of biometric data was something we were kind of in front on, and you could run into potential problems with folks generating sensitive data, because biometric data is sensitive data simply by taking a picture of someone. So this is removing that piece, aligning with other states, and the highlighted language that you see at subdivision B to say biometric data does not include a digital or physical photograph, an audio or video recording, or any data generated from those photographs or recordings, unless generated identifies a specific individual. That's consistent with what Connecticut does, and that's one of these changes here.
And just so people know, judiciary does look like they're moving a deep fake provision in their miscellaneous judiciary bill. So that was one of my concerns, is that not get left out, that that's being dealt with in judiciary.
Will it be a separate bill?
It's in their miscellaneous judiciary bill, I think.
So what would be the enforcement of that?
I don't know, it's language that the Attorney General gave both of us. So
that's the language that, we got.
It was in the previous draft of this, but we had not talked about it. And the attorney who will be working on that regularly works with judiciary, so it makes sense from my perspective that it would be handled in the miscellaneous.
Oh, it totally makes sense. I'm just wondering what the enforcement is.
Maybe the AG can speak to that.
Let's-
Okay.
Or we'll find out when we
Yeah.
find out.
this is out of.
But we were hoping that that would be dealt with in
Yes.
miscellaneous judiciary, the judicial bill, so that's great.
The next change is on page 10.
Those are tight.
You are on page 10. This is line 8. The definition of precise geolocation data. We've added language here to say that personal. So what we're talking about when we talk about precise geolocation data, again, this is the kind of sensitive data that requires heightened restrictions in place. We're talking about personal data that accurately identifies the person within a particular radius. We previously just had language to say personal data that accurately identifies, irrespective of where that information comes from. We're now adding language to say derived from technology. That is consistent with the approach taken in other states, and it's a way of ensuring that, say, someone just providing an address or particular other kinds of information wouldn't be deemed sensitive data simply by that fact. I will note that personal data by definition excludes publicly available information, so that may already pick up that concern. But just to say, this derived from technology, inclusion is consistent with other states. This is not changing in some way that is less protected than what other states are.
Right, so for the crowd, we're concerned about stalking issues and other things that require precise.
That, and
Yeah.
I think this ties a lot into the concern about folks tracking health data, people going to abortion centers and the like.
Right,
So this is
exactly,
saying
that,
Yep.
and the stalking, right?
Right, and there is a time, uh, component of this, present or past location.
it includes more than just what's happening right now.
Yeah.
So
Which is
you know,
important.
someone could go, and then you wouldn't want it to be such that a week later, someone could supply that information. At that point, it still affects them. Even though they-
Right, so if someone is at a safe house. So
Right,
they could, that location could be found by, paying for the data.
I don't know.
Is my understanding.
is that still the case?
Someone,
Paying for their location,
yes,
paying who?
paying the, someone on the internet, there are a lot of those, location finders.
I mean, I used to work at our shelter in
Yeah.
Chittenden County and people would take their phones apart anyway. I mean,
You're right, that's what they need to do, is take the
Yeah.
phones apart,
so,
but that's an issue. So,
And that's, I was hoping we were further protecting everybody.
We are,
We are.
we are
It's-
further protected. That's
or
what this-
protecting them on paper, we'll see.
I mean, the idea behind this is to limit that kind of access.
Yeah,
and to say that-
absolutely.
Which is, it's great to define it, I'm
Right.
glad there's a definition.
I mean, like criminal behavior is criminal behavior.
Right, and that's something we obviously are not talking about in the context of
Right.
this bill. It's like that's.
We would
beyond-
advise people to change the route they drive to work as well, you know,
Sure,
it's a big challenge when someone's
Right.
stalking you.
But if we can keep it from becoming criminal, I mean, if we can protect people before something becomes criminal, it's always an ideal.
And I mean, what this bill gets at is businesses that are processing data in particular ways, and so it's targeted to that kind of harm rather than. Although a person at home could technically become a controller if they did certain things to meet the scope, right? Like target products
right,
to folks in Vermont and they had a sufficient number of transactions, basically. The next change, the last definitional change is on page 11. This is to align the definition of publicly available information with Connecticut. So now publicly available information, again, this is what's excluded from personal data, information that is lawfully made available through government record or by the distributed media, or the controller has a reasonable basis to the consumer is lawfully made available to the general public. This is not so different from what was in the last draft. What the last draft had was lawfully made available through those government records, lawfully made available through distributed news media, so it's more limited. This is widely distributed media, whether it's news or not. And additionally had a piece about a controller having a reasonable basis to believe a consumer to have lawfully made available to the general public, except to the extent that it's sensitive data. So an exclusion for sensitive data the consumer had made available to the public, but was secured for commercial purposes. I get the idea behind that exemption in the previous bill. I think there's a little tension between the fact that it would have to be lawfully made available by the consumer and that it also is sensitive data. If it's sensitive data and they're choosing to make it available to the public, there's kind of a little bit of a tension there. So this is aligning more with the approach taken in other states, and is largely similar to what's in the other draft, but will be clearer to folks who have worked with other regimes.
So when we're saying aligned with other states, are we mostly saying aligned with Connecticut?
Yeah, although Connecticut matches, so this is, I should say, Oregon is really what this matches, but technically Connecticut has an and in place of an or. It is unclear to me that they actually mean their and, which is why I put
Probably.
or. Because you can imagine if you had an and, that would be information that's lawfully made available. And the controller would also have to have a reasonable basis to believe they made it available to the general public. It's available through government records. Guessing that anyway, the fact that Oregon uses an or, and has generally tried to be at least as consumer protective as Connecticut leads me to think that the Connecticut and is probably.
And forgive me, but I don't remember it, which is the newest, or most updated, is Oregon after, well, Connecticut?
Oregon is after Connecticut. Connecticut kind of started a wave of, it wasn't the first, but began a wave of very similar models. Oregon did a bit of their own things and tried to add some additional consumer protections. The general trend has been folks try to add a little bit more. I haven't kept up honestly in the last month with because there's things that have passed in the last
Well,
month,
and there's a Supreme Court decision in Illinois that,
the biometric.
yeah,
So there are, my understanding is that potentially Maryland and New Jersey may have new things going on. But that's to be seen.
I want to pause and say thank you, John, for looking at all of these states and becoming a bit of an expert, so we can't lose you after this year necessarily, but reminds me of Tucker learning about sports betting, like we
Yeah,
have
and then he
somebody who
shut it
knows what they're
back.
talking about.
But then he shut it.
I
so-
have plenty more to learn. As I was looking at this, I never looked at EU GDPR stuff until maybe a month ago, just to see kind of the origins of a lot of the data privacy that's taking
Yeah.
place across the world. And so many of the terms that are used here are drawn directly from that,
Correct.
controllers, processors.
Well, they did it first, so.
Yep.
They set
So-
the standard, although we're not fully following there.
No, and we're limited in what we can do, obviously, just with constitution.
But they don't have the same leash.
That's,
Separate.
they,
Yeah.
they have a fewer. boundaries.
So we are leaving the definitional section and jumping to your biggest change in this draft, which if we jump down to page 48,
48,
which
Yeah.
is our enforcement section. Okay, so section 2425, again on page 48, this is your enforcement. In the prior draft, two drafts ago, what we had is a call out to consumer fraud protection, which has an underlying private right of action in Vermont statute that exists. And we had an explicit semi-developed private right of action that took place in section 2425.
and that's the consumer protection sections.
The
No.
underlying is the consumer protection sections. Yes, that's right.
The first thing that existed.
Yes.
So I want to make clear, we're not doing anything to take away what currently exists in the consumer protection law for the private right of action that currently exists.
We are for this bill, yes. So
Okay.
I
am
am
not
not
okay with
taking
that.
it away.
I am not okay with taking away a current right that the consumer protection.
It's not taking that right away, it's matching the data broker section, which says the Attorney General has the sole enforcement, that's been on the books for a decade.
Right.
And it's putting a study together of how to create a private right of action. That makes sense. We don't have any education dollars right now to even help educate businesses on this, so I think we're a divided committee on this issue, but
I don't mind us looking at going forward, but you know, we disagree on the private right of
I do.
action. But to take away what is a current right that exists in the Consumer Protection Act, I am really not okay.
well,
sorry, just to clarify, when I say when I'm affirming that it's taking it away, what I mean is we initially included in one draft a call out to the underlying consumer protection statutes that pulled in that private right of action. We are removing that section.
But we're
Obviously, the
not.
bill does not yet exist, so we aren't removing a right that has independently existed. We're saying we're not deeming this to be a right that will be picked up by consumer fraud protection. So we're not doing anything to the underlying statute, we're just not using it to pull in that private right of action. But the effect of this is there is no private right of action under this act. That's the effect, and I think that's what you're trying to.
Under
Yeah.
this act, but it will continue to exist in current law.
Absolutely.
oh yeah,
Yes.
okay.
Thank you, that's all I'm clarifying.
Oh, okay.
This doesn't touch
Yeah.
the consumer fraud statutes, and just so I can.
Okay,
walk through the-
that's important
Yeah.
for me. Okay.
And maybe this will make it clear. So draft one, we had essentially two private right of actions is the way to think of it. We
Right.
had a call out to 2453, which pulled in 2461, which is the private right of action in the consumer fraud statutes. And we had an explicit private right of action that was developed in this section. In the next draft, we removed the explicit call out, so the second private right action, and we retained the reference to the underlying consumer fraud protection statutes. And we said that the AG will have the authority to do what they do, but we didn't say the private right of action under that consumer fraud statute does not exist. Now what we say, so in the last draft, you could have had a private right of action, it just wasn't called out in this section. Now what we have is an explicit call out to say, we are deeming this to be a violation of 2453, so we're invoking consumer fraud protection. What we're saying, and I'll scroll down to this. This is the specific language. While that violation will constitute an unfair and deceptive act in violation of the consumer fraud statutes, that's section 2453, shall be enforced solely by the Attorney General, and no private right of action under that 2461B shall apply to the violation. It doesn't affect the underlying statutes, it's just saying that the sole way by which this consumer fraud violation is going to be enforced is the AG's office. That's what this is.
June, sorry.
No, I mean, I have a lot to say, but I don't know if this is the right time.
I mean, we have an hour. I think this is obviously the crux of the disagreement here. The next section is about a set of recommendations that would bring back a private right of action to it. The whole reason we heard from the Attorney General, they wanted a specific private right of action, was to name the harm threshold of $1,000 in damages for having a specific figure in there. I think between ADS and the AG's office, they can think more about the cure period, the education, and what the correct amount is for this violation. If you look in Title IX, whether it's robocalls or propane or other specific consumer protection violations, there are different specificities around the private right of action. We heard from the chair of the other committee, if you want, just delay the private right of action. Instead of just delaying it, we're actually asking people to do more work and come back to us with an affirmative decision about what it should look like. And that is the responsible thing to do as far as I'm concerned. And we can have a disagreement about that, but I'd like to get through all the language first.
Okay. Yeah, I'd love to put I just have a question on this, which is,
Oh, you questions?
yeah, the question here with this is, so a consumer couldn't bring a larger suit under what currently exists. That's what this
A consumer
is.
cannot bring a suit under this act. The only enforcement will be through the Attorney General's office. That's correct.
Right, so that is, okay, so that, I just
Yep.
wanna,
And just to scroll up to the language above this, chapter not to be construed as providing the basis for subject to a private right of action for violations of this chapter or any other law. So it's making explicit no private right of action here, but it is deemed an unfair and deceptive act in commerce. So it is a consumer fraud piece. It just doesn't have a private right of action. That's what this is.
anyway,
So maybe we will come back to this at the end. It sounds like.
Right. I mean, I will say what is materially unchanged is the private right of action in-house was pushed out a year anyway. So
But it still existed.
It
This is
exists.
taking out its existence.
I'd like
So-
to look at the next section because I think most of us plan to be back here, so we may get this
should
conversation.
we plan on it, we have to get elected though,
Well, it's gonna be just as difficult a conversation.
it's gonna be a difficult conversation.
They will be far more informed and we will have a budget request in the beginning of session for education, which we do not have now. And I can't responsibly have people subject to major exposure when they have not had a chance to even understand this bill.
I think we could find $100,000 to do that education.
Yeah, I do too, anyway, let's finish the language and so then we can chat.
All right, so on the next page, we have the piece that Chair was referencing. Previously, we had a not fully fleshed out oversight board, and we had a separate section on education and outreach that also wasn't fully resolved. What we now have is, you guys heard from ADS, excuse me. I believe it was last page. Agency of Digital
Right there.
Services, yes, page 51, we are just actually past the Data Privacy Act, and we are now jumping into language.
Where's the
related to-
study part, or did I just miss it?
So
It's not
this will-
highlighted, the whole section is highlighted at the top.
Yeah, this whole section is new. So, you guys heard from ADS that they were sort of volunteering to take on this oversight / policy recommendation type role. So what this does is expands ADS's existing AI council, advisory council, to contemplate data privacy as well. So establishing AI and data privacy advisory council. This is some just cleanup type tweaks to the existing language, but the new pieces here. The council will be tasked with providing advice and counsel to the Attorney General and carrying out those enforcement responsibilities under the Vermont Data Privacy Act, developing policy recommendations for improving data privacy in Vermont, including recommendations for implementing a private right of action, and developing education and outreach on the Vermont Data Privacy Act. So that's
The ADS doesn't have this ability, I don't think. I mean, they aren't enforcers, they are technology policy people, they're not enforcers.
They're
I
not
don't-
even policy people.
They
They're
are.
our IT people.
They're IT people, they are not
internal
enforcers, and they are not,
Yeah.
But you have a former Supreme Court justice on there.
That doesn't mean that.
Where are you seeing enforcement?
well, I mean, to have ADS advise the AG on any of this is a little
The
concerning.
the AI Advisory Council, which we were on the committee when we created it,
Right,
does advise state government
all of states, right.
on technology changes and how to manage them.
But I think this is, anyway, I would love to hear a response if we could from the AG's office on whether this works for them.
Okay, we have to do it before 9:30 because this bill is going to health and welfare.
Have we not got?
They aren't possessing.
Is the AG, it's supportive of this?
I doubt it.
Okay.
They're right here.
Sarah Sebas, Attorney General's Office, no, you're not supportive. All right.
To soldier on. The advisory council additionally has the authority to establish subcommittees to carry out the purposes of the policy recommendation section, so that would not apply to their ability to advise the AG on the enforcement responsibilities. I will note, and we can jump down to this. Let me call out the members, new members to be appointed, one member representing Vermont small businesses, and one who is an expert in data privacy. It is worth noting that the existing members of the council would similarly be part of the decision-making regarding data privacy, and the new members, the small business representative and the expert in data privacy, would also have say in AI policy development as well. So this is just to make clear that this is a council as a whole that's being expanded, not bifurcating in any way. But the piece that I did want to call out is the limitation. We're on page 54. That the advising council of the advisory council shall not limit the discretionary authority of the AG to enforce the Vermont Data Privacy Act. Need to do this to preserve the AG's independent powers. So the AG needs to maintain their authority to enforce the act. This is just to make clear that the advisory council is providing advice. It is an advisory capacity. It is not controlling what happens with enforcement. And then just to call out that subsection G above that, some clarifying language to say that in its advising council, the advisory council shall consult with enforcement authorities and states with comparable comprehensive data privacy regimes. So this is setting up your expanded council to address both future development of a private right of action, education and outreach, and also some limited oversight of the AG's enforcement responsibilities. That's what this section is meant to accomplish.
Senator Cummings.
Have we asked them?
They actually
I
suggested
remember having them in.
So ADS did, but not
And
the AG.
can I
Yeah, sorry.
finish? I'm assuming there's going to be a cost to putting additional members on there. Have we calculated that?
the per diem that they receive. I mean, ADS felt they could do this in-house. I did ask them about like, we don't have any money, does that change things? So ADS did feel at the time they could do this in-house. They also suggested that on their subcommittee, they could invite more people who are not expecting a per diem.
Yeah, these are all people that we don't have, I mean, these are not legislators, so it's not a cost to us.
Right, it's an existing council that they manage, that's not us setting up a study or anything.
Most of it would be $50, but if we're still, they are council people, but.
And
We get our money's worth.
I don't want it.
John,
I was trying
We've
to
tried for
direction
years
that
to
comment.
keep
last
the
time.
Not you.
That's
With an IL, not an EL.
So with that, I will jump down to the data broker section. That's section 3.
Senator Cummings, you feel
Sorry.
satisfied with that? I didn't jump on the seat. Okay,
Sorry, where are you, John?
We're on the same page. We're looking at section 3, but I will call out pages where there are changes. So the first change is starting at page 69. Sections have remained the same.
Oh, that number is sweet to me, goodness sweet. Turning 69.
Oh, okay. I was like, let's just.
That. No, for the other reason. For the more personal reason.
I am married to a Gen Z millennial.
Yeah.
We're going in dangerous directions.
We
so,
are.
Direct us toward the text.
Page 662.
69.
I somehow.
So what about the underlying stuff on 56 and 58? Is that new?
There's nothing new on 56 or 58.
Okay, it just happens to be underlined.
Yeah, if it's not highlighted, so the
Okay.
underline is any language that is being proposed in this bill, so you're gonna see that all the rest, but,
Well, the whole bill is there.
exactly.
But not new from this committee.
This, everything
Right, it's just
highlighted
new, period.
is a new draft today from what we looked at before, and John highlighted just that
Yep.
line to say, here's this new council without highlighting all the council changes.
Right, got it. But I think to go
Oh,
to
I
Penny's
know,
question,
yeah.
it's just, it's.
New
within
from the house.
Bill.
So the
From
same,
House version.
the same thing occurs in subchapter 5, right? You're just highlighting the,
Yep, I'm highlighting this
Gotcha.
because in this, subchapter, the changes are not going to be apparent. I will call out what they are.
Right.
In subchapter 5, you're gonna see a lot of text here on page 70. It looks very clean. That's actually what I'm trying to call out, is that you have clean language. In the bill that came from the House, there were several changes to this language. They were flow-through changes that came from the substantive change that we will come to shortly, which is they were flow-through changes from inclusion of an individual opt-out for the data broker section. So
This bill is going to finance.
it should
There's
anyway.
a fee.
Yeah.
there
I-
are civil
I
penalties.
think it's going to finance. I don't agree.
Yeah.
But they already exist in here for the data broker, the fees.
The fee does already exist.
Yeah, so you shouldn't have to.
The civil penalties, I don't know if that will affect.
Everything's been going to finance
Only
that.
John Blumer thinks
Yeah,
that.
wait.
We've knocked out a few bills this week that had no fees in them. They were somewhere in history.
Right, but I'm just
I don't
saying,
know if
that
it'll-
I think the fees that exist
Yeah.
in here already exist.
That registration fee does already exist. I will come to the other language, which you guys have already seen, but I'll call out mine as we
Okay.
get to it.
And this is the list that David Hall testified that no one had ever applied.
This is what he testified, I believe, saying Secretary of State did not want to do this.
But that's gone.
That's gone.
This is their existing
That's, yeah, that's
structure.
what I thought.
We took
This is
out the
list.
$8 million cost for a small list of
Yep.
non-figure data.
So this specific section is about annual registration. That is an existing law. The reason I highlighted this section is just to call out that we are returning to the original formulation, other than this cleanup change to internet. Because the opt-out for data brokers has been removed, and so you don't need to make changes to this section. So that's why that's highlighted. The real actual change, the removal of the opt-out occurs on page 72. But at the bottom of page 71, you will see some.
Sorry, I think there is one new thing on the fees, which is on page 71, line 12.
Yep.
Yeah, that-
So you guys have seen that civil penalty, that's been in the draft
Just
all along.
pointing out, that is one fee change.
And it removes that cap as well, but the change you see at the bottom is that this is talking about, and this is new language in the bill from the House, this was the proposed idea. In the registration section for data brokers, that if they omit required information from their registration, they would have to file that omitted information within 5 business days, and they would be liable for certain penalties after that fact. This has been extended to 30 business days, and you're gonna see this again below on page 72. The same thing for filing of materially incorrect information. There's a civil penalty that kicks in if you file that materially, if the data broker files materially incorrect information, that remains in place, 25K. But if they fail to correct it within a certain number of days, it was 5, now 30.
Was there a
They're,
reason for giving them 6 times the amount of time?
And it's even more than that, because it's business day, not a lapse.
uh,
I mean, is it,
And they can do things.
Because I think if I remember correctly, we now have overlapping policy on who's a processor, a controller, and a broker. We mashed controllers and processors on top of brokers. And so more people may have to register, they have to know what applies to them. So I harmonized a majority of the notice periods because this may bring in newer, smaller entities that we already determined have limited ability to turn around a policy response or reaction in 5 days, so.
Except data brokers are all big companies. There's no little company here. A data broker, this is only applies to data brokers, correct?
This is for data brokers.
So I'm not
I
worried
don't
about
know
their
that they're
size.
little.
Well,
I mean,
I'm not
they're
worried
big,
about
so-
them not knowing about this stuff.
I'm
They
trying to
already-
harmonize this whole bill because that wasn't done.
Okay, so
They,
Still, it is
anyone
a
who's
lot more
registered
time.
now is already complying.
I get that, but to go from 5 days to 30 days is a lot of time. Difference.
5 days is a very short.
These companies operate.
Very sorry, these are good sized companies that know what
Okay.
they're.
I am having trouble. Everybody talks like we've had testimony about harm and size of company and what they're doing that harms me. I don't feel harmed, and I had my data stolen from the state of Vermont. I'm trying to, I feel like there's a subtext here that I'm having trouble getting my head around.
The only harms that were brought to us were from the Attorney General. They were largely security breaches, which we've already tried to talk with them that this bill doesn't change that. One of the major cases in Illinois was about fingerprint data and a manufacturing company. That the Illinois is changing their HIPAA, their privacy act,
Because
and taking away class action
I was
lawsuit and changing the
fingerprinted.
language.
twice in 6 months
Mm-hmm.
as a board member for VSAC because so finally, the last set is going into
Right.
the national registration. that
Right.
Says I'm not likely to rip off students. But I also have fingerprints on file with the federal government.
Right. But
Because
you're-
I was a Vista volunteer. They're stored somewhere.
Mm-hmm.
Right.
The only
But
accurate,
what's somebody gonna do with them?
the only accurate testimony we've heard that relates to this section is David Hall saying 3 people have called
Oh, I
to
thought
find
he-
out more about
Oh, I
their
thought he
data.
said nobody had.
I think he said 3 people.
Yeah, he said
Period.
there were a certain number of people who had called and then fewer people taken advantage of whatever was happening.
Yeah, we heard testimony from the AG that they've gotten a lot of calls.
Yeah.
They
AJ
did
said
calls,
a
they
lot
said a
more.
lot of calls about security breaches, that's what I read.
Right.
Right, so
Oh, yeah.
security breaches.
But security breaches lead to the data being in the wrong hands, and
I've been notified the state had a security. breach.
well,
Well, the Equifax
Yeah.
breach was a huge challenge for this state. I will
I
remind
tried
us that was
to
the last big one we had. And it was, we don't,
yeah,
my guess is we
Bill-
aren't even clear on all of it.
The bill came to us with an exemption if you're involved, if you are subject to the Fair Credit Reporting Act. So nothing in this bill changes what would have happened in the Equifax case. Security breaches do happen, they are problematic, people call the AG, people, have remedies, but nothing in this bill would change that.
And what the bill does do on that side is require notice of data broker
Right.
security breaches.
Yeah, well, that's
part.
I think
why we did the.
the bill is definitely much better than nothing, even after we've changed it. But it's not as good as it could be, and as we received it from the House, I think it was much better and protected consumers better. I'm sorry that we haven't had more time. Senator Cummings, I tried to get a sample of a record of someone's data, just so I could show you, because I know it's financial data, it's medical data, it's all kinds of things that are protected on the incoming, when they're collected.
Yeah.
But they're not protected after they're there, and folks have ways to get that data, and they'll sell it to you. But I was told that it's very difficult to show one of those samples because they have 1 billion pieces of data for an individual, for each person. There's up to 1 billion pieces of data, so that's photographs,
You have
that's where you've been.
I mean, I think we all know we
No,
have a billion
no,
pieces of
exactly.
data on our phone.
Right, well, and it's not just in our phones, now, despite the best efforts of companies, because we, the government, haven't regulated it, it's the wild, wild west out there. So, and a lot of business, so appreciate that you're including businesses, that's critical. Businesses were included in the House conversation, when they were, working on the bill initially. I found.
Different than the language that came.
Well, I found that businesses actually appreciate rules, because right now, this whole field is like, it's
Wild
like,
West.
it's a wild west, and it's like watching hockey on television, where you can't keep track of the puck.
We heard
But
from
we are
car
the
dealers that
Yeah,
they have to hand this over. I think we don't disagree,
Yeah,
they want clear rules and the
Right,
ability to
and-
follow
And
them.
we had clear rules, we're getting clear rules, but without enforcement, the rules don't matter, and the
The
one
AG
thing
has
what
enforced.
I heard the AG say was the PRA was the most important part, and that it wasn't as draconian as a PRA could be because of the right to cure, because there was a
Right.
period to cure. And so that made it not like the patent trolls.
Which,
So,
and the right to cure is what convinced most of our House members, which is how they would so
Right,
strongly
right.
support it.
right, so I just wanted the pendulum or the balance of power here is so much in favor, not necessarily of the companies who are with us, but the other companies that are around, and just the whole system. The consumer has very, very little rights. And when the consumer has more rights to their data, they actually provide more data to those companies, so the companies would be better off if they had better, clear protections.
This,
So I
clear
would-
protections is what this bill
Yeah,
has.
so I would.
This harmonizes with other states in a way that we before could not explain the language to others.
We didn't spend a lot of time with language.
I spent a lot of
Others-
Time with it.
So, should we just finish this and then let's
I know.
launch into.
I was actually gonna say that, I don't wanna cut off this discussion, but I did feel like we were entering like
Yeah.
actual discussion.
So 30 days of lines, I guess I'm happy with that at the moment. Why don't you finish?
Yep, so the last substantial change here is we're on page 72, line 12, the data broker credentialing section. What happened here, the reason this is highlighted again, I can't show a removal. There were previously the general opt-out and individual opt-out sections for the data brokers. That's exclusive to the data broker sections. This is not about the Vermont Data Privacy Act. All the opt-in and those provisions remain in place. Exclusive to this section, the opt-out has been removed, and there's two reasons. One, the general opt-out hinges on the individual opt-out, and you guys had heard testimony from David Hall about the general opt-out and Secretary of State's capacity, so that was sort of a separate question. Regarding the individual opt-out, what the individual opt-out permitted is consumers to request deletion of their data or that the data broker stops selling their data. The consistent responses you guys were getting were that people wanted the same capacities they had under the Vermont Data Privacy Act to respond to requests under the data broker opt-out. So under the VDPA, a controller can say, I'm not stopping doing this for X reasons. Like I collect this information because, and this is the specific example that we heard, I don't want to stop collecting this information because in the absence of this, we can't actually engage in anti-fraud. Like we need certain information on folks to be able to track who shows up to a place to verify that they are in fact who they are. So there was a request to conform the same operational provisions of the VDPA opt-out, the Vermont Data Privacy opt-out with the data broker opt-out. At the point that you actually do this, you have effectively the same section in the data broker opt-out as you have in the VDPA. And to the extent that your data brokers are already subject to the Vermont Data Privacy Act, it's superfluous is effectively what it becomes. The additional benefit that you lose by removing the opt-out is to the extent you have a data broker who is not meeting the thresholds of the Vermont Data Privacy Act, and I don't know if there are any of those or how many, if there are. But to the extent that you have someone who is not picked up by the Vermont Data Privacy Act, you would now not have these opt-out provisions for them. It would be mere speculation for me to say how many of those exist, but the thinking is that likely data brokers are meeting the requirements of the Vermont Data Privacy Act and are therefore subject to a whole host of consumer requests that didn't exist in the data broker section. So that's why those provisions have been pulled out and why you saw the flow through changes above. Happy to answer questions on that, but that's the thinking there.
Is that the last change?
The last change you won't see, which is removing that deep fake section, which is
Right.
addressed in the miscellaneous. changes.
Just a question about,
Yeah.
what, so Where is there still an opt-out? And if there is, where is it?
There is the opt-out in the Vermont Data Privacy Act. So we're talking exclusively about provisions that only apply to data brokers. Data brokers may and likely are in many instances subject to the Vermont Data Privacy Act. So
Okay,
They
so-
have-
redundant.
so let me just ask you that,
Yeah.
so there currently is an opt-out in the data brokers.
Yeah.
there was in the last draft, there is not.
So there's not in actual life, there's no opt-out
There was.
existing now.
Oh, no, there is no opt-out existing now
Okay,
in Vermont.
okay,
No,
okay.
we're not
People
removing,
really want that. I'm
we're not
very cool
removing
about
some things that already exist.
it. Okay,
We are saying,
but we're putting it in a different place.
we're saying that the opt-out that's in the Vermont Data Privacy Act is gonna be what controls what data brokers do. To the extent that they're subject to it, which is
Okay,
likely they are, but that's again an empirical question I can't answer.
okay,
That's the thing,
Thanks.
but yes, to your point,
So
Sir
it's-
Carson, the idea is that it might be redundant. And I tried to call out the instance when it might not be, which is if you had a data broker who was somehow not subject to the act, meaning they didn't do business in Vermont, and they didn't target anything to Vermonters, and they didn't derive, they're gonna derive 50% of their revenue presumably from sales. So the way they would not meet it is if they don't do business in Vermont, or they don't target things to Vermonters, in which case they wouldn't be subject to the VDPA. But otherwise, folks are gonna be, and so that's the thing.
And I think as opt-outs evolve, I mean, I am so appreciating them increasingly clearer and better all through our internet life. So it's, people I believe are taking advantage of them. The clearer, the better, the bigger, the better.
Yeah. I think so, that's it. And they need to be able to trust it.
So
The
the,
ones that don't work are the political ones, usually, honestly, or everything else they
I
actually
can't
stop.
write
you can't get out of that,
Yeah.
you're in it forever.
Yeah, I can't get rid of it.
I know.
I don't know where they got my name. I'm getting things from the Billy Graham evangelical.
I know, yeah.
All I
You
can
get more of that with this job.
But they were, no.
You do?
Yeah.
Oh,
They
yes.
started
You get on
Bill and
myself.
Barry, and I think that's where they picked up local names.
And just so you guys can see when this is effective, that AI Data Privacy Advisory Council is meant to come into effect July 1st, 2024, so allow them to build up capacity, that's the idea here. Other sections not until the year following, so Data Privacy Act and those additional pieces related to data brokers, those would take effect until the year following.
And
That's
just
what-
remind me, before I go back and go, when is their report is due so we can act on it next year?
So they don't have a report due, they're tasked with developing
they're-
policy recommendations.
They are gonna update us and give her recommendations when.
There is no specific deadline for them to do that. I will say,
I think we need one if we're gonna act on it.
sure, I will say this is not,
This is
the
not the
end of
place.
this bill is what I will.
Oh, I completely agreed. I think we now have sadly a very serious contracts committee that we always knew we were gonna have, but I guess I would feel more comfortable if we had a recommendations due at a certain, at least initial recommendations due, because quite honestly, we wanna be able to move on this next session.
They're seated August 1st.
Well, they can get to work right away. They're not campaigning.
Why does it have to wait till August?
Oh, just someone has to be appointed. This doesn't go into effect until the month before. It's actually sort of a tight term in terms of
Mhm.
appointment.
Yeah,
We could make it effective upon passage.
But effective upon passage is different than our speaker's office and our pro tem's office.
No, that's true.
Finding somebody, appointing them, making sure they're willing to serve, that's always taken a long time, and that's on us, so.
So I just think that given the rest of this act is
Yeah.
taking place on July 1st, 2025, that's the next session. So I think we need recommendations by a given date. I would encourage them to get their act together and move fast. So I would, maybe by February 1st, January 15th, whatever, I think we need them in time for us to have some time with their recommendations on something so important.
Okay. Do you want to, when do you want to say?
I should say January 15th, everyone can come to us and say, we're not ready.
Right, okay.
Okay, so you want, develop policy
Yeah.
recommendations for improving data privacy, which shall be provided to.
I think that all of, I mean, this advisory council is gonna continue to exist.
Mm-hmm.
So, I would say, yes, recommendations on what we need to act on next year, we need by January 15th.
Yeah, so would this work for you, which shall be provided to this committee, House
Yeah,
Commerce, by
I'm
January 15th?
I'm looking at page 51,
Yep.
subsection D.
Exactly.
That's where it would go. Yeah,
Exactly.
that makes perfect sense.
Yeah, that's where I'm looking, CMD. So it's the CD and E and two, yeah.
Okay.
But D is where I think we would add.
Exactly.
Yeah.
So I can make that change right now if you guys are
Great.
trying to.
Yeah, the Government Accountability Committee was recommending that anything like this be by December 15th, so that legislators can have it before the session started.
Good point.
So let's just. I mean, it's
Okay.
Well, it's,
like everything should be December 15th, because
I don't disagree.
I don't think a
Sure.
month is gonna make a difference.
I'm not gonna look at anything between December 15th.
Yeah, that's
First
true.
January,
Okay,
quite
so-
honestly.
Yeah, I
So,
think December
You
15th
don't have
is a
to,
great
but staff could.
We'll stab
Other
it later,
legislators
that's right.
I mean, and the second year of the biennium, December 10th is our deadline, so I'm not sure why December 15th was chosen, but
So anyway, I think
we
actually.
don't have a deadline in the first year.
Yeah, no, that's fine, but
No, no,
that's,
you're
I'm
right,
just
for
saying what,
staff.
that's what the
Mhm.
committee recommended, so I'm just letting you know,
Okay.
honestly. I hope that we
Yeah.
go a different path and this doesn't matter.
Yeah,
But-
no, I think normally you're absolutely right. I think for this crowd just being pulled together in August, probably just getting together in September, they're gonna need September, October, November to work. And probably just the first week of December, given what people are doing don't do. So I think actually, I hate to say it, but I think January 15th is more realistic.
Yeah. John, are you working on that?
Yeah, I'm doing.
But
I think
Randy, I
that
think,
yeah.
also though is late, because so often, we're off and running. Immediately after the beginning of January, if there's any way to get that back to at least December, I think it would be helpful, so that when we
Okay.
open the door,
I'm-
we've got something to work with.
I think we're asking a lot. I agree that it's unrealistic. We can take a vote.
they're all well paid.
Who's well paid? This
No, this whole advisory.
Oh, you're talking about legislation?
Better-
Yeah, I was like, who's?
Well, you're
none of
better
us are
paid
well
than
paid.
we are.
Dan, do you have a preference?
No.
Either way.
We're asking them to, we're asking them to take on notice. I think
December
January.
15th, having tried to get groups together during that time
Especially with election season.
year, what, are there going to be politicians on this group?
No,
Oh,
but we
good.
still have to appoint people and
Oh, yeah.
like just everything takes longer in an
The
election year.
appointments happen by August,
That's
Right.
correct, that's correct.
so depending on when in August, you're
So it's a-
giving them 3 months. I have no idea how complex the job is we're asking them to do. And we're not telling them they shall meet once a month.
Mhm. They have a existing underlying. Well, that's
Yes, they are meeting,
once a
uh,
month, usually.
so I think they were required to meet monthly in advance until February 1st, and then they can meet no more than monthly. I think it contemplates that they.
So if they're not meeting only monthly, that's a problem,
Right.
because they're never gonna get this work done in 3 months.
So we asked ADS to be here, they couldn't come on relatively short notice, they have time to go back in health and welfare and other committees. If.
How
the
about
cost
if
is-
we give, in this section, John, how about if we liberate them and get rid of the requirement that they only meet once a month and say they,
That's changing underlying how they
we're
work.
changing.
I mean, but I like to, we asked ADS to be here, I don't wanna change anything that's underlying without them. This has other committees to go to and we'll tell
Given
ADS.
they're meeting once a month, I then even more strongly feel January 15th makes more sense because they're not meeting enough to make a dent in this, I don't think.
I think that
Unless they have a subcommittee that.
I think it's more. We're talking about next year when our deadline doesn't exist, I think January 15th is fine and we can revisit.
And why can't we appoint the others before August 1st?
So the others already exist.
Right,
others,
well,
the two members.
they represent, well, it's just the small businesses and the member who's an expert in data privacy, are before August 1st.
this is a huge task that the speaker and the pro temp office have and the committee on committees have. That there are a lot of these requests, they reach out to people, it takes a while to hear back. We just don't control this date.
That's why we put
Well,
the
we could
date,
ask them.
that's why we
Leave it
put
at
a date.
August first for
I think that's why
Yeah, that's
we
why-
put a date on
Yeah.
when they have to appoint, because sometimes they
And
don't,
there are bodies that they've never pointed off.
which is bad.
Anyway,
So this is putting the fire under everybody, we hope, and getting a recommendation to us that we can act on.
and also, most groups don't meet in June and July, it's just a reality of summer and Vermont.
Sockwind is going to be meeting in June. So,
Lovely.
okay,
Okay, I will send
9:23.
Plain to Magali with January 15th.
Okay.
should we go into some of the, now we can open it up for discussion.
Mm-hmm. And we need to vote by 9:30 because John is due in health and welfare around then to start sharing this bill. Okay.
So I would, first of all, we haven't had a lot of time. I very much wish we had had more time. And I appreciate the chair's work to get businesses included. We
I
don't
feel like
wanna
this took
hurt our
all of my
local
time, but yeah.
businesses.
Yeah.
And I care very much about the Vermont businesses. I do think it would be better for businesses to have clear structure in this area. And I would propose that we consider the draft prior to this that included the right of private action, because we heard, I
Just
heard,
that piece,
no, just because
or all
There
the
have
other
been-
changes.
right, no, there's lots of other changes,
Yeah.
but it's just, we didn't have time today to really contemplate those changes. I mean, I understand them, but I mean,
I understand some of them.
Mhm.
I agree, yeah.
the most important thing to me is the private right of action. And I'm convinced, by what the AG said and what we heard from the other body. They approved it 128-0, I believe, so it was unanimous, and they spent a lot of time on it. And I respect the time that they spent, and data privacy is just a huge issue. And I would, if I can make a motion, I don't, if it's,
Sure,
I mean,
but you have to be really specific.
okay, I would
You
like
have
to
the private
go,
right of action.
well, because the easiest way to be specific is to go back to the just previous draft. The
We
draft
need-
as it was before
So
yesterday.
that takes away the data privacy addition to the AI commit, it takes away a lot of things, so I just wanna make sure that's the motion you're making.
Are you making the motion that we go back to draft 2.1?
Is that the last draft?
Before this one, yeah.
I think it's the last draft we had, 2.1, but only insofar as sections,
What would be the
The-
section, the private
the private right of action,
It's 24, 25.
20, yeah. So keeping the rest of the changes, I think.
Is that, well, let's hear. what you say.
I've got 9,
Really?
That's from the house.
That's-
Oh.
then we can get you.
Well, I think Wendy is actually recommending that. I think
We
it's,
need to know quickly.
I do like the, well, we only have the board because we don't have the private.
I think it's important that we have them anyway, we finally have.
I think the
Real data
advisory board is
privacy
a good idea.
experts and ADA.
Yeah.
So are you just recommending the private right of action be put back in?
That's the most
Okay.
important to me,
Okay.
yes.
One thing that I'd add is, although the private right of action is not specifically in this, the private right of action in consumer issues exists in law now. And so there's nothing that would prohibit people from using a private right of action based on existing Vermont law.
I think you weren't here when, John explained that we actually are removing that
There is
for
no-
this purpose.
People cannot rely on the private right of action in Title IX
In Title
to enforce this.
For this bill.
For this bill.
We put
For
in
this bill.
language.
Was
for that.
existing in the data broker section, you couldn't use, it was sole enforcement of the AG. And it wouldn't have really waived that.
so, yeah, it still exists in the consumer protection.
So
We have not
But for
changed
other-
that
For
Or other
underlying.
things, that's right.
Yeah.
So,
What are we leaving it out? what if we let private life action out of it exists in consumer protection?
Right.
In this bill, we are specifically overriding that.
It doesn't apply to this.
It doesn't
Right,
apply.
exactly.
It's two separate things.
That's what was written into the data broker section 10 years ago and has stayed there for 10 years is the AG has the sole authority. We'd be adding the same language here with the data privacy and AI council task force, whatever it is, coming back to us with recommendations in the same amount of time that the PRA would otherwise take effect because the House had pushed it out a year and recommended we push it out again if we weren't ready. I would, Senator Cummings, I don't know if you were here, you know this better than I do. We don't have any money for education.
Yeah, but the AG said they could do the education without additional money, so I don't think that's an issue.
Not
Like that.
not the
Yeah,
kind of
Not
education.
for the
that needs to-
complexity of this.
They hadn't even contemplated an RFP, how much money it would cost. They hadn't contemplated education.
I'm not sure this is fully fair because the AG did say they had the money to do this. This is what they do all the time.
Well,
They send out bullets.
Yeah, that's what.
That is, this is,
this is
We're having
more complex
this-
than
yeah,
that and is
we're-
more needy
I
than
mean,
that.
your folks, VLGS said specifically what they needed and they had not had a chance to talk to
Right,
anyone.
and I agree that the education on this, with all the businesses is gonna be robust, but I also know we have a lot of other partners that we
Okay,
can.
so it's
trying
929.
to educate the chamber.
But
It
that's-
isn't gonna be robust because we don't have any money to make it robust. My concern is that we're modeling Connecticut, that they don't have a private right of action. That is the sticking point. Our businesses
Right,
are going to have to comply with other states.
right.
I'm trying to do other,
To my knowledge, no state has a private right of action
That's what I
except on
thought.
biometric data in Illinois, which is being changed this year, and there was a Supreme Court decision disallowing class actions because of a hospital case. And two, in Washington, it's for medical data. So Senator Lyons and I have been in touch. I don't think she wants to add a private right of action in, but there is no other private right of action on commercial data.
and that's. I wanna see this up and running. I wanna find out how it works. All you need is one or two frivolous lawsuits.
Frivolous lawsuits are hard to do. They don't really do.
Illinois had 200 lawsuits and several Supreme Court cases. They are now changing their law because they believe businesses, they are calling it annihilation, that they are trying to remove the annihilation power of their private right of action against hospitals, medical care, nursing home.
And all
school
of that
districts.
goes on your cost of health insurance.
Well, this is true, cause I
I mean, the majority of people who talk to us have been healthcare folks who are about to go to health and welfare and say the same thing, so.
right, but they.
The only
have
other
their-
states that have a
that's
private
okay,
right of
yeah.
action, it's medical.
There are fewer consumers right in the room, I mean, where are the consumer lobbyists? There's one here in the AG, so I mean, I
everyone here
understand
is also
healthcare's
a
lobbyists.
consumer.
But I would,
haven't gotten any emails on this from consumers.
Zero.
Zero.
oh, I've gotten a
You
ton,
probably will.
I've gotten a
I
ton,
think it's not been on people's radar.
we've all gotten them, I've seen.
Yeah, no,
all
I'm
copied them.
I'm getting a
Not
lot more
changed.
now that
Yeah.
it's getting in the
What's
public.
this morning?
H 121, I've got at least.
I got two this morning, so there is a call out.
Anyway, I mean, and I know there are three of you that are dead set against this, but I would support Senator Harrison in this.
Okay.
I would narrow it to, and I'm sorry to hear how the developments in Illinois are, and I'd like to hear more about how they are, because I would narrow it to start with, just to biometric data, do the private right of action on biometric data.
That is a health and welfare conversation.
And that,
You
okay,
can have that conversation with Senator Lyons and the folks around the room who are
but
going to go have that conversation.
first and foremost, I see this as a consumer protection bill that's essential to pass. I think we're making huge strides with most of it already. But the private right of action really is to me something that is a key piece of it, and I'm really, real sorry to see it disappear.
I don't think it disappears. It comes back
It's in a
with
study.
much more advice and much more than basically Chris Curtis saying, I want it at $1,000 because of the Equifax case. That's the reasoning that we heard for the current private right of action, and then they added the care period. That was very short.
Yes, but it got everybody, it got at the moment, it got everybody over the line. the cure period.
And we may have a conference committee.
Oh, we will have a conference committee, I am sure. So you have a
So,
motion on
yeah.
the table.
Well,
Mhm.
if it's not gonna pass, I mean, do you wanna,
Withdraw it or do you want
Or-
to vote?
yeah, let's go ahead and vote,
Okay, so
but I don't have a, sheet.
we don't need a sheet. We
Right,
could,
like,
drop poll.
okay.
Yeah,
So,
so,
You pick that up on that.
yeah, right, yeah, well,
Let's
two
make
minutes
that
anyway.
all-
I mean, you can just do a thumbs up or whatever, who wants to include a private right of action.
yes,
So Wendy and I think, are the only two that would want to go forward with private action.
Okay.
So that clearly fails.
okay,
In this committee, and I think then the next motion.
so now I need a sheet,
Now we need a sheet. I thought you had a sheet.
don't have a blank one.
Oh, you don't have blank.
And just to
Okay.
call, it will be draft 4.1, not
Okay.
3.1, because we just added that
Thank you.
So
January
I,
15th piece.
I guess where we are at the moment is I would move we vote out favorably draft 4.1 of H 121.
Okay, so,
I'm not, I just wish I had said this when, like informally, but I do wanna say now so everyone has full information. You know, generally, it's customary that if you vote against a bill, you're not considered for a conference committee, so I just wanna
That
make
was
sure
just
everybody
some
has
vote,
the
not on
information.
the bill. The
No,
bill
I know, I
vote
just
is-
wanna make sure before we take the vote, that's information people should have, that it's not anything but information.
I'm ready.
thank you, and I appreciate it.
Yeah.
Yes.
No,
And I'll get to that when I get to my.
Okay.
So, Senator Brock,
No. I mean, yeah.
Oh, on the whole, I was like,
Okay, yeah.
I was gonna say, I thought you screamed.
thank you.
Senator
Yes.
Clark,
Yes,
Senator Cummings,
Yes.
and Senator Harrison, yes, and Senator Brockins.
Yes.
And I would vote yes anyway, I would just want to explain.
Okay,
because
yeah,
This is better than nothing,
Mm-hmm.
but it's, as I said, not as good as it could have been. So I
I
appreciate better than nothing.
Mm-hmm.
I
Oh, I'm
agree.
sorry, and the vote is 5-0-0.
Okay, for this 500.
And hopefully the feds are going to override us.
Oh,
That'd be
National
nice.
policy.
I don't know if everybody heard the feds. The
Well,
feds just did non-compete legislation, which we were actually hoping they do something that we can respond to, so things
So-
are happening.
That's true. I would say I'm also reluctant, but very much a yes, because I think this moves us forward enormously. I am discouraged by a bunch of things, just mostly lack of real time in the committee hashing this out. I appreciate the chair's work on it, but I really wish we had done more of that here with us fully understanding. And it is one of the flaws of our system is the Senate gets too little time with the crossover as late as it is. So anyway, we need to fix that for next year, I think. Because I think we need to have more time with things that are this important.
There was 2 years in this biennium, and we got it
In this
after
committee
crossover.
did not, I spent more time on data brokers because that originated here and we did a ton of great work on
Right.
data brokers.
No, I'm just saying, I mean,
Okay.
we did not get it along with our 12 other bills in enough
Exactly.
time. We still have 2 bills we haven't even heard yet.
I'm being critical of the system.
Yeah.
Yes,
Okay.
so.
Peace.
Okay.
Thank you for
We've
your
got
work.
the most
Thank you.
time of the second half
John.
of the session, I just wanna say.
I know, and
Thanks so much.
thank
John.
you for all your work.
Yeah.
on this.
And he has to go do this in health and welfare again.
It will continue.
Yes.
Yes.
You're welcome to report our vote on this or whatever you feel is material about this discussion.
All of the details.
Oh, okay,
Well, I've set the committee system for 3.1 and 4.1,
okay.
so.
And it's still probably helpful if we figure out which other committees that has to go to after health and welfare for health and welfare's benefit.
Health and welfare get on it.
Huh? There we go.
I don't.
They don't take official possession.
They're taking possession now.
No, they can't. It has to go through the floor to have official.
Oh, who wants to report the bill?
Well, I think you own it, so it's yours. I think you're the one who did the most work on it.
Okay. So, unless somebody wants to report it, I will post them.
Okay, got it.
Brandy, are you volunteering?
No.
Okay, thank you all for dealing with the time we had, which was extensive. You were here when we budgeted the time we have for different bills.
Honey, I am just saying, at 3 hours a day, we
Mhm.
do not have enough time to be able to bill this scale. And of the other stuff we got from the house, you know, it's just a frustration of the time.
Right,
It's
right. I
not-
just wanna
It's
make
not
for
with our
everyone
time,
that we looked at all the bills we got from
and we were
7
having to,
different committees.
we're having to basically curtail morning committees beginning
Yeah.
next week.
Exactly.
So that is just too little, too little.
Yeah.
That's all,
Okay.
it's all too little.
We are starting on a new bill that we have not heard yet.
Right, speaking of, and
Yeah.
also good size bill.
Oh, Bryn is here. Hi, Bryn. Oh my gosh.
Brent is doing.
Yeah,
Bryn.
and that makes a lot of sense. Bryn is used to doing walkthroughs.
Renee, have you met Wendy yet?
Yes, yes, we talked a lot. Yes,
So I
nice
get to see you in the last moments of your current capacity.
Oh, no, are you
Yeah.
leaving?
No, we have good news. I'm gonna run to the bathroom, Bryn can share.
Yeah, Bryn is going to be our new director of ledgers and accounts.
Oh, right, it's just.
Coming back to let
So we'll see you. Cool.
These are chairs. Where did we,
You have such luxury in this room. In health and welfare, if I move my chair back, I kneecap somebody.
it's like, why are all these chairs here?
Because we have lots of people.
No, you're fine. You could sit there.
He said, we were sitting on the windowsill yesterday, first time this year.
You don't have a lot of big bills this year.
Oh, this is, yeah. Okay. It's okay, they're fine, they're not, anyways.
So you the Zoom link, right? It gives it people to strange.
Unless they like it. Do you guys like it when I put the bill up on the screen? Or do you all have, imagine?
I'm looking through pot.
Yeah, I have.
I think I printed it out a few weeks ago, but I'll print it out again.
It should be in.
It's somewhere.
I think it's all one is up there.
On 21 is.
Join. Start it on screen. So, that's on different.
Oh, wait, was it, were you waiting for him?
Yes.
We're finding the bill.
Yeah, bill.
We have it, we have it. I printed it out a few weeks ago, so I'll print it out.
Lord, I'm sure it's somewhere in my house, so we'll try to find it. Six. Was it in like a folder or just?
It would have been in a folder, but I don't expect it to be.
Okay.
Tony's birthday in house. I'm joining, so I can put that on the screen.
Why don't you do that?
There's a brilliant idea.
I did.
I've got one twice. That's state of Wyoming.
Oh, okay.
I know.
Okay. Yeah, fine, right. Everything is looked on my desk.
We're getting new one.
No, we're good.
Hello,
You're
hello,
here.
hello.
I mean, it sounds like you have
You have to do your volume in two different places. Try that one, and then all of a sudden you have to go in second. Okay. Hello. Okay, yeah, that's like, got it, okay.
Must be very stimulating for people to watch.
We're working through our technical difficulties.
Here we go.
Took about 5 minutes, but I think it works.
If you zoom in a little bit.
What are you needing? There's your lever for up at there. Just stand up.
Moving.
Oh. Yeah. That's perfect.
Is that good?
Yeah.
Okay. Okay, we're gonna have to work on quorum today.
Yeah, I'll be on at 11.
Okay, oh, I might be out between 10 to 11, are you out from 11 to noon?
I don't think so, it's only 15 minutes.
Oh, good, okay, so it looks like we're staggered appropriately.
I'm here all the time.
Thank you.
I'll be the happy anchor.
Thank you.
Thank you, my dear. And because I was not making great headway here. This is like watching paint dry to the public.
Well, message.
There are 12 viewers. Okay, 6:12, here we go.
I got it.
Okay, it was mercifully short. Okay, Brent, thank you for being here. H612, our first look at it. And I will say to set the stage that I have asked agriculture to weigh in on outdoor cultivation, and I've asked health and welfare to weigh in on medical marijuana.
Yeah, thank you for sharing that, or with us.
Okay, so thank you for having me, committee. Bryn Hare, Executive Director of the Vermont Cannabis Control Board, here to walk you through draft 3.1. This is the House passed version of 612, H612, the miscellaneous cannabis bill. So you all are seeing a miscellaneous cannabis bill sort of every year after you create the Cannabis Control Board. This iteration, I would say, the bulk of it is making amendments to the medical cannabis program based on recommendations that were generated by a working group that the legislature mandated that the CCB convened during the last off session. But there are also a few sections that made substantive changes to the adult use cannabis program. There's a number of technical amendments. And as the chair mentioned, there's a couple of sections that are being reviewed in other committees, the medical program changes and then the land use changes.
And we will give time to industry folks and cultivators to hear from them about things that weren't contemplated, that, you know, just to hear how the industry's doing and if there are ways we can help, because that's our job, is to support them. Yeah,
Absolutely. So I did want to point out before I jump in, that there are two sections of the bill that the board is recommending a change to. And I will point those out when I get there.
okay.
So I'll just jump right in, start with section 1. This is a change to the definition of hemp products and hemp infused products in Title 6. So essentially what this does, this committee might remember that the board created an emergency rule about a year ago to address the problem of intoxicating hemp derived products that were for sale on various venues around the state. What happened is that the 2018 Farm Bill and their definition of hemp essentially created like legal loopholes for products for hemp manufacturers to create products that essentially have an intoxicating quantity of cannabinoids in them.
I'm sorry. I thought
Or
hemp,
you want questions as we go?
Yeah, when we passed the hemp law, we were told that, it like took a vast amount of hemp to produce anything that had any impact on anybody, that was a joke, sort of.
Oh, well, it's true that it requires a mass amount of raw material to create intoxicating.
To anything
products
that would
with
be
hemp.
intoxicating, right?
Yes, but it is not a joke.
I mean, it's still, if people are doing that.
Oh, yes. Yes,
Okay.
there's actually quite a thriving interstate market for.
Okay, well,
Well, I wanna hear the end of Brent's sentence.
I'm sorry.
So there are like large interstate manufacturers that are creating these products that meet the federal definition of hemp, of a hemp derived product, because by weight, they contain under that threshold of 0.3 THC by dry weight. But if you create, for example, like a chocolate bar, or a soda or something like that, that conversion of 0.3 THC by dry weight can result in a chocolate bar with 500 milligrams of THC in it. for example.
Okay.
So these like sort of big manufacturers are making these things, they're making edibles, drinks, tinctures, things like that, that have a large amount of either hemp-derived THC or other synthetic hemp-derived cannabinoids like delta-8 THC, delta-10 THC.
By that point, they're not marketed as a hemp product. They're marketed as a cannabis product.
I would say they are marketed in all different ways.
Okay.
But typically, yes, the dominant market appeal of these products is that they can be high.
so, sorry,
But they could be sold to children or something, is what you're saying, because they might be labeled as a non-cannabis product.
Well, there's no regulatory framework around.
yeah, I was gonna say that the problem is there's no regulation.
I thought that we didn't allow edibles. I've had lobbyists bring me back, bought from a local cannabis store, root beer barrels, and one other form of cannabis that was marketed, had a picture of root beer barrels on it.
Yeah.
I did talk to James Pepper about it, but I apparently somewhere some very high potency cannabis has made it into the market locally with high school students. One of them ended up in a residential care facility with mental health issues. They may still be there. So we've got some issues out there. I know they're not supposed to be able to buy it. They're not 18 but
Is it 21? Yeah.
Yeah,
21.
it's 21.
21, but
Yeah,
it's out there.
right.
So
Well, the permits are out there. I guess imagine while we're on hemp, I mean, the impact of hemp versus cannabis is what in terms of ingestion?
Well, if you're ingesting an edible that's hemp derived,
Yeah.
like the kind that I'm describing,
Yeah.
it's very similar. It's a similar.
So it's similar, it's not like it's more,
it takes
Doesn't have
more
more in
plants, but you concentrate.
If it has the THC, that's
Yeah.
the same.
Yeah.
Right, I would say
Yeah.
the impact is probably greater on a lot of these hemp derived products because they are, just like we said, they're not required to abide by the regulatory framework, so that serving limit, the THC per serving limit doesn't apply. Obviously, the packaging requirements don't apply, the
Right.
prohibition on selling to youth doesn't apply.
so I assume your recommendation is that we regulate it.
And this
So, yeah.
definition.
So the definition here, this is all setting you up for this change in the state definition, which right now sort of references the federal definition where that loophole continues to live. It changes it so that what is carved out of the state definition of hemp is any hemp products, hemp infused products that are either prohibited by the board or deemed a regulated cannabis product by the board. So this sort of returns to that emergency rule I was talking about, which has now been incorporated as part of our regular rules, which prohibits these synthetic hemp-derived products, or it requires that if you want to manufacture and sell these, you must become licensed by the board as a cannabis establishment. So essentially, you have to enter the regulated industry and abide by all of the rules and regulations that apply to other folks that are selling intoxicating cannabis products.
And you don't have that authority now to,
We've been given the authority to regulate these products, but what's happening is that we have created the rule and this definition of hemp is in conflict with the rule.
okay,
So, we
need to
it's sort of a
get it, yeah, okay.
Brought us a problem and a solution.
yes, at the same
Appreciate
time.
that.
Okay, so I can keep going through it. It's sort of subsection C there just says that anything that is excluded pursuant to that section that you just looked at is considered a cannabis product as defined by the cannabis chapter in Title VII. And so that sort of has this other effect of providing that anyone who's in possession of these products in prohibited amounts is committing a crime. So that allows DLL to assist us with their enforcement mechanism in shutting down establishments that are selling these products that are prohibited.
So sorry, with that.
That's just subsection C, lines 3
Right, okay.
to 9. Yep, okay, so if we're done with hemp, I can jump to section 2.
That is, FERDAP is.
FERDAP, yeah.
Hemp under control.
Yep, exactly.
And I, just a time check, we lost some time to multiple things, but we should still try to get through this by 10:30, because we've had some witnesses who have come a long way or wanted to testify. Last time they were scheduled in all of our changes. So we probably take a lighter look at the medical so we can get to folks, and we still need to vote out each 55 and 11.
That's good. Okay. So section 2 is the definition of controls in the cannabis chapter. And I would point out that this is one section that the board is likely going to recommend that you either strike from the bill or change.
Okay.
Somewhat. So I'll just set the stage a little bit, which is that we originally asked for this because, and this is gonna sound familiar, because this is the second year in a row that we've done this, but Vermont law requires that anybody who owns or controls a cannabis establishment get a 50-state fingerprint supported background check through the FBI. The FBI has denied us now twice to have authorization to receive these 50-state fingerprint supported background checks because we're not a law enforcement agency. And their rationale for the denial of our application is that the definition of who has to receive a background check is not sufficiently specific for their comfort. So this was an effort to somewhat narrow the scope of who is considered a controller of a cannabis establishment in order to satisfy the FBI so that we could receive these background checks through the FBI. Right now, we're having to contract with a third party.
So sorry, did you mean to stop sharing your?
I didn't.
Dear. Oh, you got kicked out of the meeting.
Wow, what did you do?
I have no idea.
We're walking through it, and so we have it in front of us.
Is it okay?
Yeah, I think we should keep going.
Okay.
Yeah.
So anyhow, that was the original impetus behind the suggestion of this section. However, we are, as we're considering this language in light of some of the more complicated business structures that are applying for a license, we fear that the changes made in this section might actually conflict with the one license rule that is part of Vermont statute. So I think it's likely that we're going to either propose change to this or just recommend that you strike it from the bill. And I think what I was in the middle of saying was that we do, just so nobody thinks that we don't do background checks.
You do it, but you contract with
Some
some
contract with somebody, and that, the majority of that.
Speaking of data that is bought for different purposes.
Yeah.
Right? So that data, those fingerprints exist in another place. You can go find the data on those fingerprints and buy it from somebody else.
That is, I'm not sure about that because the FBI has very specific parameters around.
But if FBI isn't giving it to you, you're getting it from someone else, you said.
We are getting, it's not fingerprint supported, it's a self-disclosure of where a person has lived in the last 10 years, and then we go to our contractor goes to those states and pulls the public records that are available from those states on criminal convictions.
Got it. Because that's really what you're looking for. It's
Criminal convictions in the last period of time for anyone who's applying for
I
it.
assume that you're also looking at federal issues,
Yes.
and are you doing that?
Our third party contractor is doing it, so I have to find out how to do it. They do it through public records, they're not doing it through.
I assume it'd be something like PACER, for example, where
Yes,
you're looking
exactly.
at
Yes,
court cases as opposed to conviction.
Yep. stuff like that.
So are you asking us now to strike this section?
I think that we're going to, I know that you have a lot of witnesses to hear from, so I think, yes, it's probably going to be our recommendation that we strike it. We would confirm that with you that when we are marking up the bill.
Okay.
Section you want to strike again as well.
Two.
All right, so the next, section 3, so the next several sections have to do with the medical program, and I can just describe very generally what these, several sections do. I'd say this is really sort of the bulk of the bill. And then we can move on so you don't, so you have still a lot of time. So essentially what section 3 through 9 do is create a medical, use endorsement option for adult use retail licenses that would grant retailers who have this endorsement, which would be granted through the board, the same authorizations to serve registered patients and caregivers as the current medical dispensaries. And so that would include the types of services that only medical dispensaries are authorized to provide, like delivery, curbside pickup, tax-free sales, other types of products that are prohibited in the adult use market.
And it doesn't change the threshold to be considered for medical marijuana.
No, so it doesn't, so, section 3 changes the prohibited products statute only to the extent that it says if you are a retailer that has been approved as a medical endorsement retailer, then you are not subject to the prohibition on possessing the prohibited product. Because right now that prohibited product list applies to the adult use program. So
There is one addition on page 12 of a condition, but I think people can see the full list of ways you are granted a qualifying medical condition there.
yeah, so the medical condition, there is a change to, there is one addition to the medical conditions that make you eligible for a patient card.
But
So
so, Brent, won't this just put all our dispensaries out of business? I mean, they're already challenged right now. Won't this further exacerbate that problem?
Yeah, so the, I would say that the time has come that the medical dispensaries no longer have a viable business model. Given the dwindling number of registered patients in the state, we have fewer than 3,000 registered patients in the state. And the economies of scale are no longer allowing for that to be a viable business model. So we've had closure of, at least 2 of our medical dispensaries, and it's likely that we will see closure of additional medical dispensaries.
So we're aiding that here. I mean, so are we saying, so where are more retailers are medical dispensaries expanding their ability to become cannabis retailers? Or is it the other way around? Because these sections imply that it's the other way around, that the cannabis retailers are becoming dispensaries too.
This allows a cannabis retailer, if they choose, to become a dispensary, if they meet certain thresholds set by the board through rule.
Because there are some people we have heard that don't want to buy it as a retail thing, but want to continue to have it as a prescribed medical aid, right?
Well, it's not prescribed. So if we remember the way that,
Right.
the way you have access to the medical program is that a healthcare provider confirms that you have whatever qualifying condition. Yes. So I'll back up just a little bit and just remind this committee, because you were thinking about this a lot last year.
Right.
And the Senate Health and Welfare Committee created a working group that was tasked to look at this issue and figure out how to create a viable medical program moving forward now that we're in the world of adult use. So that stakeholder group met several times during the off session. 3 sort of alternative approaches to doing that emerged from that work. One was to sort of do as you might be suggesting, which is to improve the economies of scale for the existing dispensaries by sort of dramatically opening up the qualifying conditions, the list of qualifying conditions, so that we could essentially see more patients join the medical program. Another option was to eliminate all prohibitions around potency and delivery in the adult use market, so that those sort of benefits of being a medical patient would exist for everybody. And the third avenue is the one that the board sort of chose and proposed in this bill, which is to allow certain adult use retailers that wish to serve medical patients and can meet these thresholds, and are willing to sort of subject themselves to this additional regulatory oversight, regulatory requirements around confidentiality and employee training and serving registered patients could do so, and that would open up more options for patients. throughout the state.
So,
Mhm.
sorry, I hate to say on, but
No, that's important.
do we have a notion for our medical patients of how many cannabis retailers would be interested in doing that, so that we have coverage statewide? Because I guess my concern is, as the medical dispensaries close, we're losing opportunities for a certain set of customers. And patients, I would call them patients as opposed to customers. And so my concern is that their ability to get what they need is
Would
not
diminish.
yes.
Um,
So how many are interested, and are we gonna have statewide coverage?
So that's a great question. I don't think I can answer it really well right now. I know that during the process of these stakeholder group meetings, there were licensees that joined this, because it was obviously all open to the public, and there were licensees that joined and indicated that they would be interested. I think it was around 10 have indicated their interest in a public forum. And also the bill sort of sets the fee requirement very low. It's essentially a $250 fee to get a medical endorsement. And obviously the board hasn't created the rules around this yet, but the idea is to make, is to sort of minimize the regulatory burden while still ensuring that the retail establishment would be offering all of the required benefits to medication. So, creating a physical structure where there could be confidentiality, and that doesn't necessarily mean.
Consultation.
Exactly. So the idea might be that, I think that the board's envisioning a set of rules that would offer options to a retailer to meet those requirements. So rather than requiring a separate entrance, maybe they will require, certain days of the week are only medical patient days, or certain hours that they're open for patients. Things like that.
I have to go to the pro-temp's office and then try to be back sooner than anyone else has to go at 10:30. If not sooner, we will
Right.
transition to our
We'll
other
keep-
witnesses.
we'll
You have your
keep the
agenda.
Yeah.
Okay.
Yeah, but we'll discuss this more.
Yeah, no,
So I would like to hear from folks who've used those medical dispensaries, because my understanding was that they really value them.
Yes.
So
Yeah,
I don't wanna just dispose of them
Yes.
without some more thought.
Yeah, and the idea really is not to dispose of them. And another thing that the bill does is dramatically reduces the cost of the dispensary.
Yeah, because it was
Okay,
again very high. So it's not just getting rid of them, it's so dispensing with the dispensaries.
Yeah.
It is, it sounds like it's sort of incorporating and folding them into the model that seems to have evolved as a more robust business model.
right, but it's very different feeling for the
Yeah,
people, and I just wanna make sure that the people who are comfortable.
yeah,
Yes,
I think that's the big concern.
and that's where I think what the bill does is it directs the board to conduct rulemaking around what.
And patients are on the board, right? This board, this group that would be looking at,
Oh, the stakeholder group?
yeah, have they be stakeholders?
Yes, there were a number of patient caregivers that stated in the stakeholder group.
Oh, I'm sorry, I thought something was in the future.
No, in the group that
No.
the convened.
Oh.
Yeah, the group that convened last summer and fall to create these sort of recommended pathways for ensuring that the medical program
Mhm.
exists.
So it'll
they were
just-
part of that process.
Okay, but the process to make the rules, that would just be the board.
Oh, the rulemaking process is always an open, lots of stakeholder input during the rulemaking, administrative rulemaking
Okay.
process. In fact, the board is sort of notorious for engaging
All right.
very open, thorough, public engagement
Okay.
during process.
And patients go to that as well.
Absolutely.
Okay.
And because patients are registered through the board, we have means of inviting them personally.
Thank you.
Okay. So I'm gonna skip ahead to page 8, because page 8 contains a provision that is not, that actually impacts the adult use program as opposed to the medical program. So this, right now on page 8, we are in the section of law that directs the board to conduct rulemaking,
Sorry, what page you on?
around cannabis establishments, page 8. And there is a provision on page 8, lines 8 through 10. That allow the CCB, actually directs the CCB to adopt rules, around, performance standards for a cannabis cultivator. That would require a,
Is it new language? It might be a little further
It
down.
might be.
look at that.
So it's on.
Do you wanna look at this?
It's G is not requirements for medical use endorsement, including rules.
I must have a different version.
Requiring
Performance
access.
standards, that's line 1.
Performance standards,
Okay.
Romanet,
Anyway, yeah, so line, that's what it is.
yeah,
Mhm.
Romanet 8 at the top,
Performance standards, yeah.
Okay.
Exactly. Okay.
and then
Oh.
further down.
Yeah, sorry. Thank you for that. I just had to try 30. Same version, but. But it's. Anyhow, so this directs the board to conduct rulemaking that would allow for, performance standards. That would allow the board to either relegate a cultivator into a lower tier or expand, a tier that might not otherwise be available to new applicants. So this language is, very similar to a provision that exists in Massachusetts, the Massachusetts Adult Use Regulated World. And it's a way, to sort of allow the board to more dynamically regulate the amount of, licensed, square footage of cultivation in the state. So right now, the board, I think you might know, the board has slowly closed the larger tiers of cultivation over the last several months, so that the only tiers of cultivation that are now open and available for new applicants who want to cultivate cannabis in the state are tiers 1 and 2, so the smallest tiers of cultivation.
And so,
Sorry.
for those of us who don't live in this world,
Yes, I'm
why would we want to reduce larger farmers
So, we're not eliminating any people who have.
who already have, I got
But
that,
we're sort of closing those windows so that we can't have any new ones, and
so
that's,
why,
and that's because,
we're oversupplied.
we do not want to have an oversupply.
So
So
this is controlling the
it's
scale
controlling
of
the
the market.
supply, yes, exactly. So one of the things that the board is really, very focused on is not, creating a huge oversupply of raw material, which would tank, the cost of cannabis. And it could also result in, a bunch of cannabis that can't be sold. And one of the states that really had struggled with this problem in its early days of being a regulated market was Oregon. And they're similar to us in that they also have a lot of outdoor cultivation. So the Oregon regulatory body didn't initially sort of limit the amount of outdoor cultivation that could take place. And that resulted, in sort of an enormous oversupply. That really had a negative impact on the wholesale price of cannabis. So the board is trying to take a dynamic approach to controlling, the supply of cannabis in the state, and, this is a suggestion for the board to be able to do that, sort of more effectively.
So the board would have the authority this is like soccer in, Europe, where they regulate them down to a, lower tier,
Yeah.
lower
Exactly, so
group, so.
the idea here, and this is again a directive to the board to create rulemaking around this.
Okay.
The board would have to engage in the public engagement process to develop rules about this.
But the board would decide.
Yeah.
The folks wouldn't apply to be lower tier.
Right, the idea is that any new cultivator would sort of be forced in as a small cultivator. And then if they were able to meet like this production threshold and sell all of the product that they produce, then they would be able to scale up at a time.
Okay.
So you want this language?
Yes.
Okay.
Yeah, no, they're,
This is not the other change, though.
she wanted us to get rid of section 2.
Sorry.
Okay, so,
No, but they just said there were 2 changes.
Yes, I haven't gotten this.
Okay.
Yeah.
I just. Sure.
so that's the controlling the supply.
Yeah.
So that the cost of cannabis doesn't tank. I got that, big
Okay.
picture.
So now I'm gonna go to page 9.
So wait, what happened to the bottom of page 8?
Oh, yeah, sorry, the bottom of page 8, where I am. So the next section is
I'm glad we're here.
location or siting requirements. That's where we are now.
Yeah.
This is another directive to the board to create rules for retailers. And this requirement is, essentially would be allowing the board to consider criteria such as population density, and the needs of the market when reviewing a new application for a retail license. So right now, I think everybody here knows that, under current law, the municipality can't host a retail establishment until its residents have affirmatively voted to opt in. And one of the consequences of this policy is that we have some,
Desert,
we have some cannabis deserts,
cannabis desert.
certain areas of the state, and then other areas of the state are experiencing sort of an unnatural retail density. So this provision would allow the CCB to consider criteria like population density, and the number of existing retail establishments and other needs in the market when they're evaluating whether or not to approve a new retail license.
But can I suggest just a word change to just be considered, that instead of increase, just be improve? Cause you might have areas where there are too many. So you don't necessarily always want to increase it. I would think you want to have a good distribution. So it just, if you consider that.
Well, I think the increase is not to the volume, it's just increasing the geographic distribution.
Right, but I would say improving the geographic distribution instead of increasing, but we can talk about that later.
Makes sense to me.
That's what you're about. So, Ben, just ask while we're on this. How many establishments have we already done, and how many, and we're in all 14 counties, right? But just not in all 252 towns.
Yes. And recent establishments, there's over 70, I would say there's 70.
70 plus, and some in the pipeline.
I
Got
can
it.
tell you exactly.
So we're in all
Has
counties, so
with a dispensary.
75.
You know, thanks, 75.
we're at 75.
Oh, well, I think so.
And how many are at the moment, to go to Ann's question, I think, how many in the previous sections? How many are joint at the moment, joint, as it were, joint? How many are combined retailers and medical dispensaries? Are there are some, aren't there?
Yes, I believe that there's one. right
Oh, there's
now.
only one.
Is anyone, can you? I'm just going by the signs driving by. The
So
dispensary used to be
Yeah.
behind the present
not,
store.
yeah, not anymore.
Not, yeah, okay.
So now
it
it's
has
just a
to go.
retailer?
Yeah.
Okay, so there's one
I
combo,
believe there's one combined, yes.
and where might that be?
So
Step, okay, thank you.
And it might, oh, sorry, go ahead.
So in terms of depth, I mean, if we're in all 14 counties for retail, but not all 252 towns, it strikes me that the big concern here is making sure that we have dispensary options in all counties as well. We only have it in one at the moment with the combination.
Dispensaries are. People aren't using them as much because they don't need to go get a card from the state police.
Right, exactly. And so that, but there are people, as Wendy and I have at least been hearing from constituents who are concerned that this option is disappearing forever. And so I love this addition that the retailers can have this dispensary section, just like a CVS has a pharmacy section. They can go and get a consultation there. Okay, let's keep going. Sorry, we're going down one of those lovely rabbit holes. So we have cannabis deserts, which is what you're addressing here in F, and G is
Right.
the medical use.
We don't have liquor stores in every town.
Alright, I was thinking that.
That's true.
It's an
Yeah.
intoxicant. I don't know that I think it's a bad thing that there's places that you have to drive 10 miles.
That's certainly those towns' choices. I agree, but you're just taking this into consideration. That's all, right?
Yes, absolutely.
Okay, and G,
Okay, so and G is. I think this is the provision that directs rulemaking around that medical use endorsement for retailers. Including rules requiring access for patients under 21. Because we do have a number of patients who are. Use,
So that would be, so a doctor would say that it was okay, right?
yes. Doctor.
And
would
if there
confirm
were
a
any-
qualifying condition.
Okay, but and that the quantity and potency, I mean, could the doctor specify that too?
The doctors are not engaging in any sort of prescribing of cannabis because they would be at risk of losing a license if they did that.
Right.
So what they do is they confirm that the patient has a qualifying condition and the board receives that verification form, provider verification form. That indicates that the patient has a qualifying condition, and that's what allows them access to the medical cannabis program.
But for a patient under 21, you might want to restrict the potency.
This whole thing is medical because the feds banned any experimentation. This is all kind of in the experimental stage. There's no studies that say this is the appropriate dosage. The story that moved this along originally was a child, I believe was 2, 3, who had seizures. Many a day, and ended up going to Colorado because cannabis slowed down,
Seizures.
helped them to control the seizures. And that was a big press story, but the only way you're gonna find out the correct dosage.
Well,
You've got some experiments, experience with people that are running the dispensary. But this medical study, they're
Right,
starting to come out now, but there's no long history of.
Right, and so we have always enabled medical use for under 20.
oh, we have,
Yeah,
okay,
we always have.
So that's to answer your question.
okay.
I'm sorry, I didn't realize that's what you were asking.
I think that's where she was going.
Yeah, yeah.
Hey,
it's
you
just,
know,
I
we're
mean,
like this today.
We
Well,
have,
I'm this-
and one thing I would just point out that this, is that the Senate Health and Welfare Committee is looking at all these provisions of the bill and also hearing from sort of the cannabis researchers.
Okay,
about
So then why are we doing this? Why are we duplicating effort?
Just so we know what's in.
So
Okay,
you know what they're.
okay,
So-
but what's the next?
Yep, so the next changes are, at the bottom of page 10, this is sort of the specific requirements around the medical endorsement. So retailer can obtain that medical use endorsement. And if they do, they are permitted to sell tax-free cannabis and cannabis products to registered patients or through their caregivers. And they can also sell products that are otherwise prohibited for sale on the adult use market, so that's the high potency products and other things. And then quantities that are in excess of that single transaction limit that apply in the adult use market. And then they can also provide delivery, that is also prohibited in the adult use market. And allow curbside service as well, which is also prohibited in the adult use
So-
market.
The key thing, Wendy, also is, I would think that the reason people would want to keep the medical option for themselves is it's tax-free
well,
when you buy.
yeah, that's part of it, but then it's also not wanting to go to that kind of,
Exactly.
they feel
Yeah.
weird.
It's like the
There are-
ladies that wanted us
Yeah.
to
Yeah.
allow sherry to be sold in grocery stores.
Because God
Because
forbid,
they did not want to, they did not want to be seen going into the liquor store.
Oh,
They were ladies,
okay,
and ladies don't go to liquor stores.
Okay.
And several years, we've never gotten that alcohol content into the general store, but that was the request.
interesting, okay,
Okay.
very cool, yeah, similar
Okay, so let's,
motivation.
All right,
let's keep moving.
Section
I'm
6,
not smoking
Yeah.
it,
I'm drinking it. Yeah, you have that option too, I think.
okay, so section 6 is just the fee, and as I noted before, the retailer with a medical use endorsement, would be subject to a $1,250 fee, so it's just a $250 bump from the regular
Just
retail.
come and find it.
Yeah, there are a few changes there too, so section 7, now we're sort of near the top of the.
That's a
page.
very low increase compared to where the dispensary fees were initially.
Yes, and that, the changes to those dispensary fees.
It's
are in here.
astonishing. Wow,
Much different.
how that market has changed.
Yes. So section 7 adds a qualifying medical condition of ulcerative colitis. So that's one addition to the list of conditions that could qualify a person for the medical registry. Happy to talk about that if you'd like. Otherwise, I'll move on to section 8.
I think let's.
Okay, so section 8 is just a change in the number of times that patients are required to renew their medical card, and to reduce it from 1 to 3 years for all medical patients. And that just
We're
reduces the-
increasing it to 3 years.
Exactly, sorry, extends the renewal term from 1 to 3 years for all registered patients. And that's really to reduce the administrative burden on patients.
Where am I?
So that's a benefit for them.
Up to 3 years here, but it's not underlined, so I don't know why.
Yeah, yes, it's struck, because right now there's a 1 year, it's a 1 year term for chronic pain as a qualifying
Right,
condition.
it's just silly,
Yeah.
okay.
Yeah. Okay.
So it keeps so it keeps their registration good for 3 years.
Exactly.
All right, because chronic pain used to be a way to get around it, now they don't need a way to get around it.
The
Well, we don't need to talk about it.
Okay,
I know what I mean.
But
Even if it's wrong.
and you're gonna have more fun.
Okay.
On page 13, you got more fee increases.
Yeah, so the
Or
fee
decrease.
decreases, so 13 is, these are the fees for the dispensaries.
Wait up,
So
Which
we're,
is going down.
yeah, so we're
I
reducing
don't like that.
the fees for the medical dispensaries, so they're more commensurate with the fees for the adult use program, because right now, they're subject to a $25,000 annual renewal fee. And our, just for comparison, our adult use retail fee is $10,000, so we're dropping it, so it's half of the adult use retail fee. And that's really in consideration of these people, dispensaries are only serving medical patients. So they don't have access to the market share, the retailer.
And is this the lowest you can go?
Yes. I think,
Yes, right.
I mean, it's a business, it's still a business.
There is we do understand that, House Ways and Means would like to undertake an analysis, a holistic analysis of CCD's fee structure and next year's fee bill.
That's a good idea.
Maybe that we review.
For next year. I think that would be great if we never
Okay.
get a fee bill. At which Ways and Means just created their own fee bill, so maybe they'll start that with this. Next year, so the days of the fee bill. Question. Brand, we have two,
We've been together for.
yeah, a long time. So, the question I had on this. So, okay, so and how many dispensaries do we still have at the
I
moment?
think 4,
Yeah, we're down to 4, and with our height, we were 11 or something.
8, I believe.
Was that it?
I can
So it's in-
I can get numbers for you.
Oh, it's okay, it's just for whatever reports.
When the program was overseen by DPS, I think there was a different number, so I can find out.
Yeah, okay, great. Okay, let's hit it.
And it was a number of locations you're talking about.
Yeah, I think that we would just want to be, I mean, that's an additional thing you're wanting to take into consideration anyway, is geographic distribution.
Okay. All right, so section 10, this is eliminating the authority of the board to charge and collect fees for review of advertisements. The board does not impose any fee for advertisement review. So this is a technical correction to eliminate that provision. There is no fee.
So,
Okay.
did you just review it and it didn't take any time?
No, it was the board's position, and I think the House Ways and Means Committee also took this position that the review of advertisements should not impose a fee in order to encourage licensees to submit their advertisements to the CCP for review. And not create a barrier for folks to do that.
Because they already don't, like. So,
Okay, so section 11, this is. Yeah, just a technical correction there, removing an old reference to the DPS, the predecessor agency of the medical program. Section 12, okay, so this is the section that the board is going to propose change language in.
But not striking.
No, we're going to propose some different language, but I'll just tell you what this section is intended to do. And it's intended to allow outdoor cultivators to use their farm buildings for basic cannabis drying and storage without having to require the fire safety division to impose the full code or the full spectrum of commercial building codes on that cultivator. So right now.
Oh, that would make a big difference.
Yeah. Yeah, so currently, a lot of our cultivators are really sole proprietor businesses that bring in sort of trim teams, or other temporary employees.
You mean like migrant labor except for cannabis?
I'm not sure if I'd characterize it that way, but, seasonal employees, yes, around
Seasonal.
harvest time, to help move their cannabis product out of the fields, and into a farm structure for drying. So because they are often called trim teams, are
Then what are they trimming?
technically, they're trimming the plant's flower, yep, cut.
God, glad you know so much about this. I'm very
That
proud.
was the word trim.
yes.
So
Well,
they're,
yes, but that's hair too. There's a lot of, anyway, cut. Kind of trim teams, I
Yeah.
like it.
they're technically employees, for a period of time. And so the Division of Fire Safety really needs clarity on whether, because these businesses are employing people for a very short period of time, whether they would need to become compliant with a full range of commercial building code,
So we're more concerned about the buildings than
and
about the trim teams and whether they're actually.
there's,
Well, because there's
No, no,
employees
it's
going
just-
into the buildings.
Yeah.
They have employees.
yeah, so for example, you would need, like there's like means of egress, there's stair height requirements, there's, you know,
It's
you
a
guys know the sprinkler requirements. And as you also know, many of our cultivators, the majority of our cultivators are pretty small businesses operating on their current, farm, operating on their what they have, which are often farm structures, existing farm structures.
No,
So does anybody cultivate tobacco? Cause that has to be dried too.
it's very similar.
Right,
We don't have the soil or the climate for tobacco.
well,
I did.
actually Connecticut does,
Yes,
so we're
yes,
not that
they
far
have,
away.
they have a swath of the right soil. I grew up in Kentucky. I mucked
Yeah.
stalls under tobacco, was all drying in the horse barns.
Right, so I was just
I
wondering
probably
if
will be
we,
down with lung cancer for
I know,
years.
or some other stuff, I know there's a lot of.
But that is very similar to what.
Right,
they
so
do.
I was just
Same
gonna
deal.
ask if we have
Yeah.
that in our state and
Oh.
how the fire folks regulate it, but if we don't have it.
You don't have, you have to have read.
Not relevant, but.
Matt, where we've been behind. Okay, let's keep moving. We need to finish this bill.
Okay.
What do we,
We are cruising, Bryn is taking us through the changes
cool,
that you made in H612.
okay,
So, welcome to stay.
sure, that's why I'm here.
Yeah, no.
I'm here to help
No.
answer any questions, insight,
So
guidance.
this section,
We have
that
witty
is
humor,
the intent,
all the
that we may
things.
need a tweak to the language,
That's my opinion.
after consultation with the Division of Fire Safety, just to achieve that objective.
So do we need to have fire and safety here or you
I
do
don't,
that?
I've gotten new language, that we have signed up. We got
Okay.
signed up.
Great. Oh my God, here comes Pepper. It must. Okay, here we go.
All right.
So
So
you're
we're gonna-
settling that issue out of,
Yeah, then we will bring your provided language for you.
right. So we can expect new language.
Yeah, so I think I'm just gonna skip over all of the rest of the medical provisions since we are sort of at time. And move to section 15 on page 16.
Right.
And this is the transfer and appropriation of $500,000 from the Cannabis Regulation Fund to the Cannabis Business Development Fund. To fund that ongoing fund that the APPD administers for our special equity applicants. So this committee talked about this provision last year as well. You might remember that the original sort of version of the Cannabis Business Development Fund, the legislature appropriated $500,000 to that fund in order to provide technical assistance and financial support to businesses that qualify as a social equity business. The board recommended, we recommended a couple of times that the legislature devote some ongoing revenue or ongoing funding to this business development fund so that HCCD could sort of make meaningful decisions about this program and how to provide ongoing financial support and technical assistance to its social equity licensees. In the absence of ongoing dedicated funding to the fund, the legislature has sort of re-upped that $500,000 every year. And so this is exactly what this provision would do, put another $500,000 in the business development fund.
This is in the budget, do we know?
Yes, I believe it is.
Right.
So there's two 500,000.
So it is transferring from the regulation fund, which is where all of the excess tax revenue goes.
And that's how
To
it's
business
spent.
development fund, and then it's appropriated to ACCD for their administration.
Okay, so it's the same
It's the same
500,
500.
just this shows us how it's being used and authorized. Okay, thank you.
And could somebody tell us how many social equity business licensees have been granted and so how much help is actually needed now?
I can get that, I have a dated number, get for you in just a moment.
Because I mean, how does this 500,000, I mean, if they used it all? How many?
No, there is.
So are they
still
building
funding
up?
there. So ACCD has contracted with a technical service provider called Rhodes Consulting. And that provider is providing business support to all of our social equity licensees on an ongoing basis. So people are eligible for sort of ongoing technical assistance through this contract.
How they have done it with the law school, small business, okay, great.
Yeah, and ACCD is continuing to look at other technical support providers, so there may be sort of an expansion of who's offering this technical support. But
So it's basically business support, it's just,
in the absence of any ability to plan around how to offer this financial support, because there hasn't been a sort of continuous method of funding. The agency has just been providing individual beneficiary payments to each social equity individual who applies for it. So I think that
yeah. Up to what?
up to $5,000. And that initial amount was determined based on sort of the initial amount of money that was in the fund. And if there were some idea about a regular source of funding to go into that fund, the agencies together would be able to make some more, I think, long-term planning around how to best financially support.
It makes some sense for it to come out of the fees or whatever, or the money that's coming in from cannabis.
Right, and that's what it's doing, because it's coming from the cannabis regulation fund, which is where all of the fee revenue goes, and excise tax revenue goes for
Right.
the next.
And where our after-school money now goes in a way that we're not thrilled with.
All right,
So
so
I do the Department of Education.
Well,
That's
okay,
that it was written into the regular. Well, with
sorry, I forgot.
initial.
Okay, there we are.
okay, so you've got just a couple of sections remaining, section 16 and 17 both govern the land use standards governing cannabis. So what these sections do is authorize the municipality to establish minimum setbacks with some limitations between an outdoor
Oh,
cannabis.
is this the response to neighbors'
Yes,
concerns?
between an outdoor cultivation site and a property boundary. So these are the provisions that the agriculture committee is looking at.
So setbacks 25 feet.
Yes. So under current law, towns really have very limited authority to regulate outdoor cultivation of cannabis. And there are a few towns that have expressed concerns over their sort of lack of jurisdiction to address complaints about odor, especially in densely populated residential areas.
Have towns established cannabis cultivation districts?
No, this, I think that is sort of what would be set up.
That's a new,
That's sort of what's being
Authority.
contemplated here.
Yep.
and then
Okay,
outside, so what would that, do you have a different, so you have setback not larger than 25 feet if it's within the district? Right, so I don't see a number. Or if it's outside of the district.
So
so
not,
what district if they haven't been set up?
right,
No, but we have a number for if it's within the
Okay.
district.
yeah, it sets up a number
missing
for,
There's three.
Is that here somewhere?
Yeah, it's here on page 17 and 18.
you may have some,
We have 100 feet, we have
Where am I not-
10 feet
Where's 100 feet?
on top of page 18. Shall not be larger than 100 feet as
Got
established
it,
by the
okay, thank you, my pages were sticking together.
That's okay, rarely do I read
And
anything.
if you don't have zoning 10 feet, whoa, that'll encourage them to have it.
Yeah, hey, you know what got towns into zoning? Cannabis. You're getting a missive.
Thank you.
Okay, we're almost done.
yep, so effective date, are that the bill takes effect on passage, except for that, and the medical use endorsement provision, which takes effect in 2025 to give the board time to conduct rulemaking around those positions.
Great. Any final questions for Fran? I think we've been going through questions. Hi, yes, we have Bill.
I heard. Senator Ron Hinsdale is currently in the pro tem's office and we don't have a clean copy of what you want printed yet, but I'll send it to you. Okay, perfect. Thanks.
It's coming.
Sounds good.
Well, it's okay.
Okay.
Okay, terrific. Any final questions? Great. Bryn, thank
Thank
you
you.
very much. That was so
Lovely to
quick.
be with you.
So we have two sections. We're looking at maybe striking section 2 and section 12
It's
is
just new
for
language.
new language. Okay, great. Other than that, you're happy with where this landed?
Yes.
And we should move along. Okay, great. So we have a whole bunch of you. Matt, we weren't gonna hear.
I'm just here as a wall.
Anything you want to say as we set this up as a, and look at it?
No, I'm just here as a line on the
A
wall.
resource?
Yes, and a resource if you need clarification from the government operations and military affairs perspective.
Right,
So-
and so you're reporting.
Yes, I am the shepherd of this bill.
It would be helpful to know your priorities.
A shepherd, why don't you call somebody who herds ducks? Which would be more appropriate for this bill.
Essex Junction.
Essex.
I know, but a duck herder. Anyway,
I'll
Sheep
work,
are
I'll
not
workshop that and get back to you a little bit
Okay.
later.
I
So-
guess she got her ducks through a whole.
we gotta just go there. Do we wanna go with to David first or to James first? Pepper, are you still here? You're here.
I do not need to testify.
Okay,
There's-
great, then let's go to David. Okay, well, we have you then, so we have David, James, and the next David, Dave, Pepper, David, and Sam. And Sam is, which one is Sam?
Stan is on.
Sam is online, okay, great. Okay, so Dave Silver, welcome back.
Alex said to say hi.
Oh, have you talked to him recently?
Yeah, it's on all day with him last Tuesday. My
Anyway,
favorite
go,
cousin of hers. Anyway, unrelated.
one of my,
Thank you, senators.
yeah,
My name is,
good to have you.
My name is Dave Silverman. I serve on the steering committee of VCAF, the Vermont Cannabis Action Fund. I'm also an attorney specializing in cannabis law and the co-founder of Vermont's first licensed cannabis store, Flora, in downtown Middlebury. The VCAF is a coalition of licensed cannabis retailers, manufacturers, cultivators, testing laboratories, and 2 of the 3 medical dispensaries. And we joined for the purpose of addressing a few specific areas of Vermont cannabis law that unnecessarily hinders our ability to responsibly serve Vermont's cannabis customers without providing offsetting public benefit. Just a year and a half old, Vermont's cannabis industry has already created over 1,000 new jobs and raised over $30 million in direct new tax revenue. And that's not even counting our income taxes from this industry, employment taxes from this industry, or ancillary service providers and the taxes that they pay to the state. So lawyers like myself, HVAC installers, security firms, runs the gamut.
Right, just question, Dave, have you submitted this to Magali, your testimony?
Yeah.
Great. Terrific.
Nearly all of Vermont's 560 plus licensed businesses, licensed cannabis businesses, are locally owned, independent, mom and pop type establishments. And despite the very many hurdles that we face that other businesses do not face, like heightened banking costs, heightened insurance costs, and so forth, the tax penalties on the federal level, which are obscene and nothing that you can do anything about, we still contribute to our communities in all the many ways that all of our well-loved local businesses do. At Flora, for example, we give generously to our local food bank, the Turning Point, the counseling services, youth sports, volunteer fire departments, local schools, the list goes on and on. Our members are proud members of our local chambers of commerce and our downtown business partnerships. We are just like all other legal businesses in this state. We are also an industry that I believe every Vermonter can be proud of. We have taken a product that was sold illegally in disreputable ways and have turned it into something good. We check IDs very thoroughly, twice at every transaction. Kids don't buy from us. We are the solution to the problems that many of the people who are opposed to legalization in the first place claim to be concerned with. And so now that it is a legal industry, we ask that you set aside the old stigmas and work with us on a few priorities. Priority 1 for us in this bill would be to add events licenses. We have worked collaboratively with key stakeholders in lodging, venues, events planning industries, among others. We all want to create an events license scheme for Vermont that is Vermont scale, not Vegas scale. And we support Chair Pepper's February proposal made to House Government Operations with just a few minor tweaks around local control and the level of fees. And we've communicated that to Chair Pepper.
So, may I just interrupt to say, we didn't talk about events in this bill. Did the House choose not to put them in, or did we just not discuss them in our walkthrough?
It was brought up late, and I believe
the house ran out of time.
Yes, we're up against the clock.
what, house, identify yourself and then
Oh,
tell us why
sorry,
you
apologies.
chose not to.
Yes, Representative Matt Byron, Vice Chair, Government Operations and Military Affairs. I am the sponsor of the bill. We did have language crafted on events, but we just ran out of time to vet it thoroughly and find a home for it in nations.
So we're considering it. You haven't considered it, but ran out of time.
Correct. If you want to take it up, I have language drafted.
Terrific.
And the second priority that we'd like to work on here in the time that we have is that VCAF would like to to ask you to amend the law to provide for reasonable and enforceable advertising restrictions instead of what we have now. Our existing restrictions on what is considered cannabis advertising, in fact, operate as a muzzle on constitutionally protected speech, going far beyond conventional notions through advertising and impact everything we say or do, including our own websites, our in-store marketing materials, signage, our online menus, and in fact, even one-on-one customer interactions in our store would fall under the definition of advertising as written now. So not only is all of that subject to the scope of regulation, but the regulations themselves are an unprecedented prior restraint on speech because everything we say or do has to be pre-approved by the Cannabis Control Board. No other industry in the state faces that level of restriction on their constitutionally protected speech. Not even the brand new online sports gambling industry, they do not face that. And they came along after us. And while we are muzzled, illicit sellers, unlicensed sellers, including gray market online sellers, who are exploiting the so-called hemp loophole and selling products that are not tested, quite dangerous, not subject to potency restrictions. My Facebook feed is filled with advertisements that are not subject to CCB regulations for product that any Vermonter can buy online. We are muzzled, they have free reign. And the bottom line of these restrictions is the scope of them, combined with the pre-approval requirement and the 85% audience composition rule. That combination violates our First Amendment rights and our rights under Article 13 of the Vermont Constitution. They are unenforceable. If we had to go to court, which we do not want to do, we would end up with no restrictions because they would be enjoined. So we are here asking you to work with us on enforceable restrictions. We want reasonable rules in place. We are not trying to advertise to kids. We don't want to, we don't want the right to do, which we don't have anyway, the right to make false or misleading statements. We're willing to, of course, abide with reasonable restrictions, but we do have constitutional rights and we're not willing to give those up.
Okay, can I just pause there?
Yes.
That's clear. House. What does the house do about this?
With the advertising language, yeah, we also, that was another thing that we didn't have time to really vet in depth.
Thanks,
So-
you have a lot more time than we have right now. Okay, so you ran out of time on this too.
Yeah.
No, I mean, our time is like, 3 hours. So this would be something we would be adding, something you talked about.
We have had conversations with it. If you want to take up some of the language to help,
You have
Yeah,
language
it is.
already developed.
we've had conversations. I don't have as specific language on this as I do on the special events.
Okay, and
Mr. Mickenberg has shared with you language that I have seen as well and would support, although I would go with.
great, and this pairs with what we were talking about earlier with Bryn on advertising on the, where does the Cannabis Control Board fall on this?
On the specific proposed language.
Yes, I assume you've seen it, or on this contention that we have unreasonable restrictions on advertising.
We would be happy to respond to that
Okay.
specific proposal.
If and when we take it up, so,
Yeah.
okay, great,
I
so we'll
assume
wait
you
for that.
want to take it up first before you.
Yeah, no, and we'll look at David's language and Matt's language. Go from there.
And that is the end of my prepared remarks. I'd be happy to answer your questions. I think, the bottom line is for us is that we are, we wish to be treated like other businesses, and we wish to be allowed to compete with the illicit market. and provide the public safety benefits that legalization promised to do. And the more our hands are tied by restrictions that are really rooted in stigma as opposed to sound policy decisions, the stronger the unregulated market can continue to be.
So can I just follow up with that, which is what, other than the advertising, are the restrictions that you're feeling? And events, I mean,
Those are two very big ones. The other big one that we did advocate for in the House and did not win, and believe that it is too late to continue with in this session, but still believe strongly in, are the potency restrictions, which, you know,
for another day.
that is not a conversation that we're going to have today.
Right. But luckily, we convene again in January,
I'll be here.
and we don't doubt it. So those are the two big asks you have for the, and so we will, okay, great, thank you. Any questions for David?
Not now, but
Okay,
Thank you so
great,
much.
thanks. So we have language for both of those asks that we can look at. Okay, great.
Thank you.
Terrific, very helpful at this time. Thank you. So I think, James, do you want to do it? Oh,
James,
where did Pepper go? Well, then Pepper's down here. So then we're gonna turn to Victor.
Can I actually defer to Sam, who was here last time?
Sam, I feel like you drove all the way up here last week or yesterday, sometime recently.
I did,
Was that
yes,
you?
yes.
Well, it's good to, where are you?
I am currently at home, so
Where is
I'm right now in Burlington, but my farm is based out of South Hero, Vermont, and my family operates a dairy farm in Grand Isle County in South Hero and Alberg.
Right. So I don't think, because you didn't get a chance to testify, we didn't get a chance to introduce ourselves. And Dave
Yeah.
already knows. Okay, so we'll just quickly introduce ourselves, beginning with it.
I'm Senator Ann Cummings. I represent Washington County District, so state capital.
I'm Allison Clarkson. Lovely to see you. We saw you last week. Windsor County District, Majority Leader and Vice Chair of this committee.
I'm Randy Brock. I represent Franklin County and part of Grand Isle County, and I'm the Senate Minority Leader.
Senator Wendy Harrison, and I am at the other end of the state in Windham County.
And our chair will be back shortly, Keisha Ron Hinsdale, South Burlington. So more your neck. Randy and Keisha are more your neck. So tell us what you'd like us to know.
Sure. So my name's Sam Bellavance. My family has a dairy farm in the Champlain Islands. We're a member of the DFA. I've been farming ever since I was a little kid. And in 2019, I started growing hemp on one of our cornfields to diversify our farm a little bit. And 5 years later, my businesses Sunset Lake CBD and Sunset Lake Cannabis employ 15 people in South Hero and Essex Junction. And really what I want to talk about today is advertising, but beyond that, just marketing and storytelling, because part of the reason I was able to grow from, growing a couple acres of hemp in a cornfield at the back of our dairy farm to being a successful vertically integrated cannabis business was telling our story and really driving home that farm, that artisan craft message that's so key to being a Vermont business. And so some of these changes to this language, specifically in 864 and 861, will make it a lot easier for members of the cannabis community to tell their story and grow their business. The changes that I've highlighted here have nothing to do with advertising to folks under 21. We feel like that's was the intent of the legislature to prevent that, and we don't want to do anything that would inhibit the ability of the CCB to prevent that. However, some of these sections, I feel like they are contradictory and unnecessary. And just to give some examples here, a lot of stores, specifically, our store in South Hero, we were doing an option where if you buy 4 joints, you could get a 5th for a penny. That was deemed to be not allowed under the prize and inducement or free sample section of 864. However, it has been deemed that buy one, get one frees are allowed. So there's a little bit of contradiction here. And I think this ties to a broader theme that I communicated with the chair when I was in Montpelier, that this language is really complex and it's really to the benefit of larger or corporately owned cannabis companies and to the detriment of small producers and social equity applicants, because it's really complicated to navigate through all this and be able to do your advertising submissions. Is the sale the right type of sale? Do I have the right language here? Is this, how do you define what is an inducement for purchasing cannabis? So I think if you're someone who is a small producer, let's say you're a sole proprietor, you don't have the funds to have a dedicated compliance officer. I know if you're a farmer, speaking as a farmer, we don't have a compliance officer. So it's very hard. I'm trying my best to navigate it. And I think these changes would simplify things and make it a lot easier for smaller producers. Furthermore, sorry, go ahead.
And when you say changes, are you referring to the changes that are drafted in the language the House had, or David has, that we haven't really taken up yet? Yes.
Yeah.
Okay. I mean, it may have been sent to us, but we haven't reviewed them as a committee yet. Right, which is what we will do soon.
Yeah, and I believe I left some hard copies with the chair when I was in Montpelier last week. Specifically around the sections 4 and 5 of offering a prize or award or inducement. One thing we do at our store Lake Effect is we have a little prize wheel where if you spend over a certain amount, you can win a free t-shirt. Under this language, that would not be allowed. To me, it's not clear why having a t-shirt given to someone who's over 21 and has been ID'd and is standing in a dispensary, why that would be a danger to Vermont and the market. So I think kind of clarifying some of that language. I don't think focusing on prizes or coupons is the best interest. The board has limited resources. They have a great team, but they have limited resources. And I think we really want to focus this conversation not on prizes, not on coupons, not on social media posts, as much as is this marketing to people under 21? And is this?
The t-shirt once worn goes anywhere and could be marketing to any age.
And I think that's something where you could say, okay, is this link? What is actually on the t-shirt? You could have some clarifying there. But I think fundamentally the act of the t-shirt, for us, it's a logo, and, the board has deemed that logos are fine to share publicly. So,
And so the language that David we'll be looking at next when we next take this bill up, it's only about the advertising and marketing, is that correct? It's not about the events piece. The events piece Matt has language. Okay, great.
Correct.
Yeah. Advertising and marketing, so you.
Yep, and to speak more broadly too about the advertising, I think something that the committee might not be aware of, for us being in Grand Isle County, we face a lot of pressure from Plattsburgh dispensaries, and right now we have been getting absolutely hammered with advertisements from dispensaries in New York, offering all kinds of inducements, all kinds of prizes, all kinds of discounts. So we're in a situation now where it's easier for a dispensary in New York to communicate with these Vermont consumers. So what's happening is the same amount of cannabis is being consumed, but now those people are driving, they're taking the ferry over to Plattsburgh, And now New York is getting the excise tax revenue. New York dispensaries are benefiting. And what we really want is the ability for Vermont producers to communicate with their customer base in a smart and effective way. So you'll also see in the language I submitted in 861, I would like to add a few more exceptions to things that I don't consider ads. For example, signage that's located within a dispensary, or communication, text or email messages to age-verified customers who have expressly consented to receive promotional messaging from a licensed establishment. So that would be an example of like a loyalty campaign for existing customers. So this is someone who's already come in, they've been ID'd, they've made a purchase. So that kind of communication with existing customers, I don't consider that advertising. That's more marketing to your existing consumers. And I don't see why that would need to be restricted.
Has that been ruled or deemed or whatever the right word is with the CCB? Because the CCB said that's not, that loyalty campaigns are not allowed.
Yeah, so what we've had situations where if it is a loyalty campaign that offers a discount, it may or may not be allowed. The board did put out a advertising guidance document following a information session. I believe that was 2 weeks ago. We are still trying to make sense of that. To answer your question, we don't know if it would be allowed or not. And that's part of the problem where it's very confusing. So if we want to send any, is this allowed? Is this not allowed? I can email our compliance officer and check, and that's, that's fine. But if you have hundreds of producers all over the state trying to verify, is this Instagram post okay? Is this loyalty message okay? Is this little sign that's on the counter in the store okay? This would require amount of compliance resources that are just not, the board doesn't have them. And as the previous testimony provided, this is not a restriction that's applied to other industries. So I don't think it should be applied to ours.
So, Sam, thank you. I think we, is there a little bit more, or are we haven't taken this language up yet. So this is just our first introduction to the bill right now. So we'll be looking at both the bill and these two recommendations that you and Dave are making. The events and the advertising marketing. We'll be looking at that and getting feedback from all concerned. And you will know when, my golly, we have it on the calendar for Friday? We do. Okay, so we're on deck for Friday, so more to follow on Friday. We'll get all the language. Could we, Matt, get your language and send it to Magali, and we'll just do hard copies to everybody, and then also David's got, I think, the language and the hard copy. So great.
Michelle Childs drafted it. I'll dig it up later for you.
Great, perfect. So I think we're gonna say thank you for right now. I really appreciate you zooming in.
Yeah,
and Dave,
thank you very much. I appreciate it. And just one last thing, I have to add this in there. Just as a farmer, a dairy farmer, a hemp farmer, a cannabis farmer, I am opposed to section 16 and 17. Farming is farming, whatever you're growing, whether it is cannabis or corn. So I just want to say that on the record as well. We're opposed to that 16 and 17 language. So thank you so much, and I appreciate you having me.
Appreciate, and yes, that's a question. That's one of the reasons those sections are being reviewed by our agriculture committee. So thank you all. Thank you, cannabis cheerleaders. We are grateful for your input, and we are going to do a radical pivot. Committee, if you need a 5-minute break. Council, do you need a 5-minute break? You're okay. Okay. Should we just keep going, or do we want a 5-minute break?
Well, I hope that I have this additional, so I've got to go out at 11:30 for about 12:30.
I'm hoping too. So then why don't we start with let me just get a sense from, you know what, let me just get a sense from Keisha. You know what, let's take a 5-minute break, let's go offline.
This is scheduled to start at 11:15, so while
It says
extra
11.
time, oh, that's my mistake then.
No, it's not a mistake, it's just there we are. So 11:15, so apologies, because it's such long on the schedule.
Sorry, then, I'm sorry.